So you said yesterday, we were just discussing, because when judge speaks, you should look at us, not with some miss.
Sorry.
Yesterday you said that a legislation has been made by the state that was struck down by the division bench. In SLP, civil appeal, apex court reversed the judgment of the division bench and revived the legislation, which brother was mentioned. He appeared in all those matters. Number one. You also said that the legislation recognizes four sub-departments. One is minor irrigation. Second one is major irrigation. Third one is mechanical division. Fourth one is groundwater. This is what you said yesterday. Where are my yesterday's notes? Not kept just
I'm sorry, Manoj. In Validation Act, none is allotted to mechanical wing and
you are all minor irrigation.
I'm minor irrigation. In Validation Act, major medium cadre, that is EIC
Make
cadre.
use of the mic.
In minor irrigation, in Validation Act, under the water resourcement, the ad hoc engineers who are validated under the cadre, in EIC cadre, that is major medium cadre and minor irrigation.
Please repeat.
Your Lordship may kindly
Your notes.
Validation Act.
Page 81.
No,
Page
you were
80.
saying something. You may.
No, my lord, from the Validation Act. That is Validation Act, serial number 1 in schedule manner. Page 82. Page Department of Water Resources. Got it, man?
Yes.
That is major medium cadre, EIC cadre. Then, my lord, page
Department of Water Resources. That is not your cadre.
No, I'm saying your lordship asking me for cadre. That is
This is number one.
This is number
scheduled to the act itself.
Yes, it is act I am showing, my lord. Then, my lord, page 89.
89.
Chief Engineer, minor irrigation, MI cadre. Got it, my lord? This is the act, Validation Act.
2. Where is groundwater? Where is mechanical?
There was no validation of engineers of groundwater.
They were not.
No, under the other departments were validated. Works department, engineering.
No, that we are not considering.
We are dispute between the EIS cadre, major medium cadre, and minor irrigation. Major medium cadre.
Who are your opponents?
Major medium cadre. That is EIC water resources cadre.
EIC
Water
WR cadre.
Page 82.
C.
Your Lordship may kindly see the date chart. Today I am furnished. On 18/6/2004, Government in Water Resources Department Orissa had their order number so and so had prepared the gradation list of assistant engineers of irrigation cadre. In the gradation list, the name of the OP number 1 was at serial number 2 and name of the OP number 1 of WPC number which is at serial number 3 manner. That is page 45, 48 to read petition. Then, my lord, on 12/7.
No, what is their grievance? Their grievance
that they file cases after cases saying that there is no such cadre minor list. So,
but legislature says there is such a.
But their gradation list remain intact. They got promotion from their gradation.
On the basis of their gradation
their gradation list. They filed the case to stall our promotion. Because of the pendency of the around 30 cases filed by them, we are deprived of getting promotion. Even though we got promotion in the year 2006 to the post of executive.
No, why state is in appeal?
State admitted in before the Honorable Apex Court, my lord. This case also carried to against interim order carried to the Apex Court. In that they filed counter.
Where have you stated in your date chart?
I have annexed the counter melody in my counter.
In date chart, you have not mentioned that.
Counter regarding, my lord, in my date chart, that was subsequent to this, my lord. That is why I am not mentioned. But I have annexed in my counter. My lord, the Honorable Apex Court in specially petition 47.
So your contention, essential contention would be, they have no locus standi at all.
Yes, they have no locus to challenge our gradation list.
Number one.
And they have not arrayed us as a party.
You don't want to hear the judge.
My lord.
Why can't you go for some class, for communication classes? Your first contention is, they do not have right to challenge, speak anything about your gradation list at all, because they are in another gradation list. This is your first argument. Second one, you are stopped from challenging all this because you have secured placement in the seniority list, gradation list, then secured promotion also. Whether all of them secured promotion? No. Whether those who are before the court here, have they secured promotion?
Yes.
You have to answer. You are appearing for them.
They secured promotion because...
No, we are asking.
Yes, madam.
The question is, it admits binary answer. Yes or no. Then you can explain.
Yes, ma'am.
They have secured it.
Some of them have secured promotion because they were shifted from irrigation cadre to minor irrigation cadre. Because the posts were vacant there, they were promoted and posted there.
That's all right. But in the legislation, you were treated as a separate
yes.
cadre.
In the legislation, we are tried.
That you challenged and you failed also because Apex Court reversed it.
Yes.
All through.
Apex Court reversed it, but kept it open regarding this all this fixation of seniority and cadre. So for a regularization concerned,
fixation of seniority and
fixation of cadre also.
Cadre also.
Yes.
Where it is said in the judgment.
Yes.
Let's show that judgment of the Apex Court. What he is saying.
Annex A by 6.
A by 6.
To my counter.
To the counter.
Is it true? You are giving that?
No,
yes, give that.
Is 87.
Now all the subsequent litigations have come up because of para 71, my lord.
Para 71.
My lord. 20.
Just read 71. You read it because you appear in those matters.
There is some debate, lots about it.
At the bar.
The debate at the bar whether the case at hand is covered by corollary to proposition A or B, proposition B. But having been given consideration to the submission of the bar, we are inclined to agree with Mr. Rao's submission that the case at hand is more appropriately covered by the proposition B, which is extracted above. We say so because the initial appointment to adopt assistant engineers in the instant case was not made by following the procedure laid down by rules. Even so, the appointees had continued the post uninterruptedly till the Validation Act regularized their services. There is, in the light of those significant aspects, no room for holding that the grant of seniority and other benefits referred to subsection 3 of the Impugned Act were legally impermissible or violated any vested right of this in-service assistant engineers appointed from any service.
Please do not disturb once.
My lord.
Don't disturb.
Thereafter, Lordship, Honorable Supreme Court referred that ultimately also kind turn to page 81. Para 81.
No, 71 again you read it. There was some disturbance.
Yes. There is a murmuring out there. Please.
That minimum discipline should be maintained. Otherwise, we will not and we will deny relief to those who are disturbing. We know how to give our reasons for denying relief to you. Yes. Just watch with an eye who is disturbing the court. We'll give you a small name of the advocate. Let
May I put again,
come
my
here. Yes.
Sorry, my lord, pressing again, my lord.
Yes.
There is some debate at the bar whether the case at hand is covered by
Can
corollary.
you read 70? Because in 70
Yes,
articulation
my
is
lord.
there.
That is, my lord, that is the Constitution bench direct equity judgment there para proposition A and B.
Huh.
The Honorable Supreme Court has accepted the proposition B, my lord. By
Initial appointment is not following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till the regulation of the service in accordance with the period of official service.
Counted. Thereafter, my lord, the Honorable Supreme Court para 71 has accepted that validation act is valid. May I placing, my lord. There was some debate at the bar whether the case and is covered by corollary to proposition A or proposition B supra. But having given our consideration to the submission at the bar, we are inclined to agree with Mr. Rao's submission that the case at hand is more appropriately covered by the proposition B extracted above. We say so because the initial appointment of attack assistant engineers in the instance case was not made
Because they were not appointed in accordance with rules.
not rules, my lord.
Even so.
Even so, my lord. Because initial appointment of the ad hoc assistant engineers in instance case are not made by the following the procedure laid down by the rules, even so the appointees had continued in the post uninterruptedly till the Validation Act regularized their services. There in the light of those two significant aspects, no room for holding that grant of credit and other benefits referred to in subsection section 3.3 of the Validation Act, Impugn Act, were legally impermissible or violated by any vested right of the service assistant engineers appointed from any other source. Thereafter, the Umadevi judgment has been proposition A, B, C. Let's see, kind of come to relevant portion, para 82, man. Para 82.
No room for holding the grant of seniority and other benefits referred to in section 3 or 3 impugn that were legally impermissible, or violated any vested. Let us see 3.3 of the Act.
That is 78. Yes, 78. 78.
78.
8 of 8 petition.
Section 3.3.
You're on page 81.
Read that.
My lord.
The services
Lordship rendered.
rendered.
Kindly conjointly, my lord, also 1, 2, 3, it will be easier for my lord's
Okay, all.
Notwithstanding anything contained in the recruitment rules, 799 assistant engineers belong to the discipline of civil, 57 assistant engineers belong to the discipline of mechanical, and 25 assistant engineers belong to the discipline of electrical, are specified in the schedule with their names, date of birth, date of appointments, and the name of department or which they work on ad hoc basis. Such appointments shall be deemed to be validly and regularly appointed under their respective department of the government against the direct recruitment quota of the service which is effect from the date of commencement of this act, and accordingly no such appointments shall be challenged in any court of law merely on the ground that such appointments were made otherwise than in accordance with the procedure laid down in the rules, in the recruitment rules. The inter-se seniority, 2 minor. The inter-se seniority of the assistant engineers whose appointments are so validated shall be determined according to their date of appointment on ad hoc basis as mentioned in the schedule, and shall be enveloped junior to the assistant engineer of that year appointed to the service in the respective discipline in their cadre in accordance with the provisions of the recruitment rules.
1 second. Well, just can you explain this number 2?
My lord. The cadre, my lord, the cadre is, lordship knows the cadre is the strength of service as 11 of the that has been defined. Every department has its own cadre. Suppose engineering state have to mind departments are concerned. Waste department is independent cadre. Irrigation, water resources now, water resources it is independent cadre. And urban housing department is also another cadre. Except these 3 persons, 3 departments who are appointed under the by the time of the planning and coordination department as stipend engineers. Now they have initially prepared a list of stipend engineers. From the list of stipend engineers, all have been deputed to different organization department to work as stipend engineers. Subsequently, when the policy came up, the proposal for Validation Act and Validation Act 2001 came up. According to that, the persons who are 12,396 years, another resolution, all have to be appointed as ad hoc assistant engineer, being adjust suitable committee formed by the government. Accordingly, all the persons who are whose name is reflected in the Schedule of Validation Act, they have been appointed as ad hoc assistant engineers. Ultimately, when the Honorable Supreme Court has quashed the judgment of the court, but the substance of the direction was already accepted by directive for regularization from the enactment of the Validation Act, that is 15 to 2003. From 15 to 2003, they will be regularized prior to or on the thereafter. Intercess unit has to be done based on the date of appointment.
Date of initial appointment.
Initial appointment, the ad hoc assistant, not as
shown in the schedule.
My lord, in the schedule. When that was the come up, the gradation list for the first time was perhaps issued by the Water Resources Department, making a, according to my learned friend, separated for the minor irrigation, different for the sewing irrigation department. Now the cross the issue whether, in absence of any specific definition as per law, as per 166(3), Constitution of India rules business, business of government cadre can be formed or create or not. To my subject to pilot's permission.
No, that is a government's business.
Business, my lord.
But if the legislature does it,
but since that is what the legislation says, Supreme Court conferring examining the entire issue, come to the conclusion that the Validation Act is not a true legislation. It is only exclusively method of regularization. Since the Validation Act is nothing validated, only to regularize the appointment who are initially based on ad hoc basis. That is there already in para 12 that. Therefore, in that context, and the lordship, the most important part is how the seniority and how to prevail the operating part of the judgment para 82, my lord. 82, my lord.
But seniority is also spoken by the legislation.
Legislation there, but that is what the specifically directed. Who will be senior, who will be junior, and how the seniority has to be counted. That has been to
see that also.
May I pray, my lordship, for 82, 81 first. 81. We have heard the counsel for the interference of Hon'Ble. We, however, do not consider it necessary to enlarge the scope of these proceedings by examining issues that are not directly related to the controversy at hand. Three questions that have primarily engaged our attention in these petitions relate to the validity of the Impunity Validation Act, the regularization of in-service degree holder junior engineers who have been working for considerable length of time as assistant engineer on ad hoc basis, and the seniority position of those being regularized either under the Validation Act or in terms of direction of this court, and being issued by us in this appeal. Other issues which the interveners seek to raise, especially issues regarding grant of reservation SC/ST candidates, have not been touched by us in this proceeding for want of proper pleadings on the subject and also for want of any pronouncement of the High Court on the said question. In the circumstances, these orders have been taken to have head only what we have specifically dealt with or what would logically follow therefrom. Any question whether the same senator those regularized under the legislation or by reason of the direction which you propose to issue or issues relating to the benefit of seniority on the basis of roster point, if any, prescribed for that purpose, are left open and may be agitated by the aggrieved party before an appropriate forum in appropriate proceeding. To that extent, any such questions or aspects have not been dealt with by us in this quarter.
What 81 says, according to you, just make a gist of that.
My humble submission is the validity of Validation Act, method of regularization, and interest seniority. That is the crux of the issue before the Validation Act and by the direction of the Supreme Court. The Supreme Court has categorically, para 80.2, has held that the persons who have been appointed as ad hoc assistant engineer and whose services and validation through the Validation Act on 15 to 2023, they will be regularized from that date, and the ad hoc interest seniority has to be taken on the basis of initial ad hoc appointment and interest seniority between the all the ad hoc assistant engineers.
Interest seniority means the interest seniority within the cadre.
Within the cadre.
Not beyond the cadre. Seniority between people in one cadre, people in another cadre.
No, my lord. Within the cadre.
It has to be that.
That is my humble submission. That's a clarified the para 82.2 and 8.3. Another aspect, 6354, another petition has been, though allowed by the High Court, that has been also set aside. And they are directed to govern under para 82.2.
82.2, just face it.
Well, writ petition number 9514 12494 by 95 12627 2005 127 8630 2000 filed by the degree holder junior engineers working as assistant engineer on ad hoc basis are allowed, but only to the limited extent that the services of the writ petition and all those who are similarly situated and promoted as ad hoc assistant engineer against the proposed quota reserved for insurance junior engineer degree holders shall stand regularized with effect from the date of Orissa validation. Engineers Validation Appointment Act 2002 came into force. We further direct that.
What they said here?
This is, my lord, the writ petitions which are allowed by the Supreme Court. That has been allowed by the Supreme Court because these persons are appointed initially against 5% quota. Total direct recruitment quota 67%. As per the policy decision of the state, a junior engineer who have acquired the degree qualification.
This is graduate engineer.
Graduate engineers. They were appointed from 96 to 98. They are 86 in numbers.
They are all seniors to these people.
Yes. These people are appointed. Yes. And that
they must be seniors going by date of entry.
No, that has been considered before the Supreme Court by Honorable
How to seniority will be fixed, that has been decided.
No. Dr. was arguing before the Honorable Supreme Court has clearly considered, since they were earlier appointed 5% candidates, they will
naturally they will be seniors to
senior.
These people.
And those persons who were appointed later, they will be treated as junior. That's why the Honorable Supreme Court has clarifying para 8.2. The basis of Validation Act regularization is 15 to 2003, and basis of seniority has to be taken interstate seniority from the date of ad hoc appointment. The total 86%, 5% group has been appointed.
Yes.
45 numbers from the Water Resource Department, 28 from Works Department, and 13 from Urban Housing Department. These are the 86 numbers.
Right.
These people were enveloped senior to the stipend engineer group.
These challenges.
Got it.
The junior engineers were challenged the validation.
Well, that has been restored. That is now nothing to argue or that.
It is already blocked. To that extent, it is blocked by the judgment of Apex Court only.
Yes.
One second. Your challenge. Do you mean to say that the judgment of the tribunal runs counter to what has been observed by the Apex Court? How? Show that.
When the judgment dated 26/2/2018 of the State Administrative Tribunal in 134 of 2017.
Yes.
This is at Annex 8.
What tribunal has said? Let us see. Go to the operative portion of the order. Which direction of the tribunal runs counter to the judgment of the Apex Court? That is the crux of the matter. Nothing beyond, because there is a legislation, there is interpretation of the legislation by the highest court of the country. Legislation is ultimately what Apex Court says it to be. Okay?
That has been
now, according to you, which paragraph of the tribunal judgment runs counter to the inner voice of the judgment of Apex Court?
Para 20 and
20.
21, 19, 24.
19 also?
19, in fact, they have narrated the vote.
19 they have narrated.
Read 19 and 20 together.
This is an extreme case.
Go to 19. Where is calling that?
Page 164.
This is an extreme case of illegality committed against the applicant in particular.
Extreme case of illegal committed against the applicant in a particular engineers of the MI Cadre in general as respondent number 1 and 2 directly violating the government resolution of November 1991, resolution of 94 and dated 1998 in Annex 3 has been filled up the promotional post of superintending engineer and engineer of the minor irrigation cadre.
Minor irrigation is a distinct cadre.
Distinct.
This is what tribunal has said.
Yes.
That runs consistent with the observation of the Apex Court on the legislation. Even in the schedule to the legislation, they have mentioned.
That is a way to be regularized. So for this legislation of 2002 million, which came into force in 2003. So far this validation
Correct.
act is concerned. By giving periodical promotion, that I am reading out here, deputing the engineers of the irrigation cadre, by giving a periodical promotion to the engineers of the irrigation cadre from Annexure 1, 2, and 3, souls in Annexure 19, and order dated such and such, referred as Annexure A to the counter, so also stand taken in the counter. It is crystal clear that the minor irrigation is a distinct cadre.
Four.
Is to be filled up by giving promotion. Therefore, the promotional post of minor irrigation cadre is to be filled up by giving promotion to the engineers of the minor irrigation cadre only, and not by deputing the engineers of the irrigation cadre.
Engineers of irrigation deputing.
By giving promotion to the engineers of the minor irrigation cadre.
What is meant by that?
They don't form a separate cadre.
Who?
These are my MI cadres.
You mean to say there is no MI cadre at all?
Yes.
That runs contrary to the very schedule of the act.
The act itself, which has been in 2002 and effected from 2003. But that was a process and a way to regularize Miller. All other things has not been taken care of.
No, that's all right. But suppose if the statute is founded on certain substratum. For example, every employee shall be entitled to maternity benefit. Substratum is every employee who is having womb. It cannot be male employee. Though in so many words, legislation does not say. There are certain things which legislation presumes, because it is women who have, they are entitled to maternity benefit. That way. In so many words, they cannot say. But legislations operate on certain assumptions, which we call as the substratum of legislation. Here, the substratum of legislation is MI is a separate cadre, because it is in so many words stated on the left-hand side of the schedule.
But so far the cadre definition under the school, it will be
now, when legislation says like this, what legislation should say should be given respect, or what rule made by a executive should be given effect?
Obviously
legislation. Even if rule says something, a rule cannot override. How? But if in the normative process, please understand, there are some students, therefore I am telling this. There is a best book on this. C.K. Allen, Law in the Making. He has explained this. In any system written constitution, we have constitution as the grand document. Okay. Then under that we have legislations. Under the legislations we have delegated legislations or subordinate legislations. So, when we are interpreting, we follow the hierarchy of norm. First, it should comply with what the Constitution says. Legislation should comply with constitutional requirement. Delegated legislation should comply with requirement of the parent legislation. Okay. Suppose if there is some delegation, then for regulations, this bylaws, these things, we need not travel to that. That is not the case. We have only a legislation, and we have a set of rules, presumably, as I assume, under proviso to 309 of the Constitution. Your rules which you are speaking of, They must be such rules only.
But that is not
Or business rules.
yes, business.
Business.
It's a business.
Business rules are also not legislative instruments. They are in the nature of delegated legislation only, because the business rules are promulgated under particular article of the Constitution by the
166.
government itself.
166.
166. By the government itself. But when the legislation speaks, that should be respected in the Apex Court. Apex Court said in a few judgments, Apex Court has said, one judgment is Manohara Parikar versus so and so. One latest judgment, 2008, 9, 10, I do not exactly remember. But the gist of that is this one. Now, can you cite a rule to counter what has been produced by the legislation? Legislature says, all they shall be deemed to be elephants. They will be deemed elephants. In English legal history, there is a famous statement. The parliament can make men into women and women into men. That's how they have spoken in English legal history, parliamentary history. We may not travel to that level. But we admit that legislation is upheld by the Apex Court now. It is obvious. So what legislation is saying, that we have to see first. Then what rule is saying, we have to see that. Whether there is the conflict between these two, we have to see that. Then we have to decide to whom the primacy should be given. This appears to be the normative way of our approach to this matter. Now, you are challenging the judgment and review judgment of the tribunal also. Is it not? The tribunal structured its judgment based on the legislation, statute.
And the
It
counter.
appears that way.
And their counter also. They arbitrated in the counter.
Counter also, that's all right. Now, which reasoning of the tribunal runs counter to the Apex Court?
Well, that is the operating part. I'm reading now.
The 19 you are reading now.
Yes.
Half you have finished.
In the instant case.
In the instant case.
I left the answer. Deputy engineers of irrigation in the instant case. The applicant being the senior most in the minor irrigation cadre was promoted to the post of executive engineer by the government order resource number such and such 9/10/2006.
Correct.
But subsequently, wrongly,
The same order
has been withdrawn by subsequent notification written 16/9/2009, which was in fact by virtue of the order of this honorable court as well as in the content petition. Keeping in view that was withdrawn. And the applicant should have continued pursuant to his promotion to the post of executive engineer by notification dated 9/10/2006. Then he might have retired in the chief engineer or minor irrigation. But most unfortunately, he has made to retire
in the cadre of executive engineer.
executive engineer. So great injustice have been committed against him, and it seems to type of injustice must have been committed against the other 12 persons who had been promoted to the post of executive engineer in notification dated 9/10/2006. Subsequently, the same was allowed.
That reversion order did what? Reversion order dated 16/9/2009.
Yes.
What it did?
9/10/2006.
No. 16/9/2009.
16/9/2009 reverted the post of assistant executive engineer.
Reverted from the post of?
From the executive engineer to assistant engineer.
That is.
It was 16/9/2009, Milord.
May take 5 minutes
On the
leave.
post
Yes.
of assistant
Very
executive
well, very well. Yeah.
16.
9/10/2006,
Yes.
promoted to the post of executive engineer. Then on 16/9/2009,
Reverted.
to the post of assistant executive engineer.
That is 353.
And
Yes.
subsequently,
353.
No.
yes,
Yes.
subsequently,
Again,
in 2014, promoted to the rank of
another cadre.
deputy executive engineer,
Then executive engineer.
then executive engineer.
Deputy executive engineer post was created. How?
May-
Where?
May I submit? In the year 2011, my lord, cadre was restructured. Deputy executive engineer inserted. And at the same scale of pay, assistant executive engineer and deputy executive engineer,
A change of name.
only change of name, and on promotion, one increment. Then that was continued. Even now that was abolished. That was also again changed, and the assistant executive
Earlier position.
earlier position is restored, and the additional chief engineer is inserted in place of the superintending engineer. So when I was promoted, during that point of time, the cadre was assistant executive engineer, then executive engineer, then superintending engineer level 2, superintending engineer level 1, chief engineer.
That's how the
Hierarchy.
Yes. Mr. Mohanty, now show where is the violation. The tribunal appears to have brought about justice. Maybe reasoning, always reasoning can be subject matter of scrutiny. Reasoning, see, objectives, you are in 227.
Yes.
If order of a tribunal, statutory tribunal, has brought about broad justice to the parties, the other infirmities will fall into insignificance.
My grounds in para 10.
Para 10.
Yes.
Go to para 10 of the appeal memo.
Page 7. I read it.
Yes.
It starts from that in the aforesaid OML, which is the 134 of 2017 before the tribunal. The OP number 1 apparently suppressed the several material facts. That he stated that his career as stipend engineer during the year 1991 and was appointed as an ad hoc assistant engineer during 1998. For a period of 1 year recommended by the OPSC, whichever is earlier, and he continued on an ad hoc basis for years without being selected by the OPSC and regularized in service by a validation act during 2003. Prior to such regulation, a common gradation list was prepared, and upon validation of their service, the ad hoc assistant engineer were allotted different departments without considering their merit of choice. He also did not disclose the original application that he was given a conditional ad hoc promotion as executive engineer in the year 2006.
Whether he had produced the promotion order.
Before the tribunal?
Yes. Yes.
He had produced.
Yes.
Yes.
It is there. That was
He
annexed.
has produced the promotion order. It's where is the suppression?
Without prejudice the same.
No, you have structured this paragraph as if he has committed some sin. But he has produced the promotion order itself, which will speak
But that is a
whether it is conditional or not.
That was a conditional.
No, that's what. No, where is the suppression? If that he kept quiet about that in the pleading, he had not produced that order along with his pleadings, there is scope for argument. He has produced the very promotion order itself.
That was a conditional order.
Correct.
That is my.
Where has he suppressed?
And may not.
No,
That is the only problem that exists.
even in the suppression.
That was,
Subject to the
that was
final
reflected in the
Huh?
order. That was reflected in the order.
Order itself. That very order is produced by him.
And may not, then the Honorable Tribunal in OA number 4 ways, this has been order dated 5/12/2005, passed in WPC number 15380 of 2005, to which he had not raised any objection, as reverted in the year 2009, that is 16/9/2009. In compliance with the order dated 24/1/2007 of this Honorable Court, and in the contempt dated 1155 of 2006, arising of the WPC number 13,178 of 2006, to which he had also not raised any objection, so far the reversion is concerned. Had he not suppressed the fact?
No, the very, that itself is questionable now. The whole paragraph is structured on a premise that he has suppressed something. But he has not suppressed because he has produced the very order itself, which said it is conditional. Where is the suppression? Did you take up that contention before the tribunal? Show your contention?
In the counter?
Yes.
That is
That he has suppressed
255.
all this and therefore he should not be given relief at the hands of the tribunal.
They have filed, not filed counter. I have filed mallet.
They have not filed counter at all.
I have filed
Enclosed.
They have enclosed. They had filed but not enclosed.
255 mallet.
255. It is 257.
That's from nothing has been uttered. Rather, they stated that because of the litigations created by the irrigation cadre, their promotion could not be considered. And they
Kindly come to page 259 in our paper book. Maybe print number 3, page number 3, internal page number 3 of your counter.
259.
259. Move down to page.
That even though applicant has submitted your page 3 of your counter, internal page 3, that is running page is at 259 or 256, something like that. One page this side, that side.
Para 6 minutes.
There is no paragraph. Unnumbered paragraph in that page is third. Above verification. You have admitted. Could you place your hands on that? That even though, yes, sure.
Yes, ma'am.
Please face it.
Even though the applicant has submitted
Series of representation
for his promotion to the next higher rank, the same could not be considered
because of
the cases which are pending before this Honorable Tribunal and Honorable High Court.
yes. Moreover,
Detailed are given in Annexure A. In the meantime, the applicant has been retired from government service on attaining the age of superannuation, that is 31st January 2017.
if details were not given, he is not Pakistani. He is your employee.
Yes.
Hey, mister, your representation you have sent, but they lack the material particulars because you are a model employer under our constitution. You are not East India Company.
Call for the
You should have called saying, Mister, whatever you have submitted is not sufficient. We want X, Y, Z. Give those also. Number one.
Yes.
Number two, how pendency of the cases would come in the way of consideration. You could have said, we have considered the representation. We want to give relief to him, subject to outcome of the cases. You have done that way in number of cases. At least in 2 cases, that is your submission of government, Orissa government submission before the apex court. We have done this because there are many cases were pending. We have only stipulated this is subject to outcome of those cases. Twice in two reported judgments you have said that with your learned advocate general, his submission is recorded by the apex court in two reported judgments. Why not here? In the review, how you had structured your review? Just show that. Kindly be sit. Come back.
Para 219.
Sit down, brother. Yes. 219. What was the error on the side, on the part of tribunal? You had filed a review. Whether separate rules are there for review jurisdiction in the tribunal?
No, man. Order 47.
Order 47, rules 1 and 2 of CPC. They are made applicable.
Yes. So far as the review is concerned.
Where is that? Which
Administrative Tribunal Act, my lord, it is.
In Tribunal Act is that?
It has been.
I'm not sure that one. Administrative Tribunals Act 1985.
85.
CPC is applicable.
Is it? There is such a provision.
To section 20.
Some provisions.
Only for review.
Wherever.
Review is there.
Okay.
Section 22 for us, my lord.
Whether tribunal has got review power?
Yes, by the Tribunal Act.
Okay.
But I remember 22.
Any court, any high court in the country or the apex court has said tribunal has got review power. Anybody on the service law? Yes, brother. You are not seen nowadays. Why?
In case of Gopabandhu issue, that issue was raised, referring to the power available under section 22 of the Administrative Tribunals Act, the Honorable Court has delivered a judgment.
Holding it has review.
Yes.
Review power.
Power under what circumstances? Who are the persons aggrieved to move that review out?
So that is also limited.
Yes.
That's also.
That power is there.
Limited purpose.
Then procedure and he is very good in service law. That's is subject to science. So anyway, if already there is such a view available by the division bench, appointed bench, then we cannot go into that matter at all. All right. What error the tribunals
Read that operating person. In ON number 134, para 4, 2017, the operative person of the order reflects in para 20 and 21 as follows.
Just
division itself. Section itself says review power.
Yes.
Yes. Brother, in your review petition, where have you taken up the contention? What is the mistake in the judgment?
I'm reading out the judgment.
Not judgment. In your review petition, what was the defect you pointed out to the tribunal? You have committed error like this, rectify it. Which is that? Where have you stated? What was the error which you pointed out to the tribunal?
they pointed out the error in para 18.
Para 18.
18.
Review judgment. You go to review judgment of the tribunal.
Review judgment is 219.
It's 219.
Yes.
You're right.
220 last parameter.
No, that the tribunal has said. You said the apex court's status quo order is not discussed. And had it been discussed, the outcome would have been different. Tribunal said it cannot be because apex court itself said if employee has already retired, status quo is not applicable. And he had retired. He already retired by that time.
2007.
Where is the ground for review?
That is the only ground.
But then it goes. Now we have to bank upon the order, original order. Now we understood. You cannot argue much on that. Firstly, review limited jurisdiction. Therefore, your challenge to review also will have limited jurisdiction. Much limited than what otherwise the jurisdiction under 227 would have. Because the measure of power of the review court is the measure of power of this court. Suppose if magistrate's order is challenged before us, the power of this court is that of the magistrate himself, not beyond that. Similarly, in review, whatever constraints that operated in the review jurisdiction, those constraints would operate against us also. Because we are not in appeal now. We are in supervisory jurisdiction. Therefore, your ground fails. Review absolutely no reason, no rhyme, no reason, no rhythm in your review petition. We'll go to the original order. What is the fault in the original order?
That I am reading out, my lord, page.
You take out your ground first. Yeah, in a review petition, only one ground was urged before the tribunal, that it had not discussed about the status quo order of the apex court, and that had there been discussion, the tribunal would not have entered the original judgment the way it has been. First up, the tribunal has specifically answered this question, saying that the status quo order of the apex court itself said that it would not be applicable if the employee had already retired. First off, it is not in dispute before us that the said employee, that is response number one, OP1 had already demitted office on attaining the age of superannuation on
2017.
Date.
31 January 2017.
Yes. So it's it hardly needs to be stated. The measure of power of this court under 227 is the measure of the power of review under section 22, under section 22 of the Administrative Tribunals Act 1985, which otherwise arguably could be a bit wider. Yeah, nothing. So that review, there's nothing in no mistake in the review. Now let's go to the original order.
My original orders and my ground to the appeal.
Yes. What is the ground you have taken?
N Miller. N.
Paragraph 10. That is suppression of fact.
Yes. Ground N Miller.
Suppression goes now.
Ground N Miller.
Ground
N.
N.
Yeah.
The learned tribunal failed to appreciate
that there was no recruitment of engineers.
No recruitment of engineers through any requisition of the Watershed Department to Odisha Public Service Commission indicating vacancy of the graduate engineers against the MI cadre.
That pales into insignificance. Because legislation has
22
legislation.
legislation.
Legislation is what is the legislation? Validation.
2000.
What is being validated? Which arguably was all illegal, unauthorized, irregular. Entire thing is whitewashed. The nature of validation legislations are discussed by C.K. Allen in a very beautiful book that law is made. There are judgments also, validating acts, which Basu in constitutional law mentioned, dedicates several pages what is meant by validation statutes, which otherwise was illegal, unsustainable, or did not exist. All that becomes valid because legislature is declaring it is valid. Legislature is supreme within its power. Well, how this ground is available to you?
That is the only ground, my lord, which has been taken taken. That is the only ground that we have agitated.
No other grounds are urged.
Oh, that is the main ground.
No, any other ground?
My lord, so far the
Mr. Mohanty drew our attention to ground N in the memorandum of petition, which reads as under. First of all, what is your answer to that?
My lord.
What's your answer to his contention?
My
He
lord.
says, tribunal failed to appreciate there was no recruitment of engineers through any recreation water science.
In the counter, my lord, they have not raised such point before the tribunal.
They have not raised that.
No.
Counsel for OP1. 1 and 2. 1.
Only one.
OP1 submits. Contention of the kind was not taken up before the tribunal, and therefore, as an afterthought, it cannot be permitted to be taken now. First of all, he further adds that even otherwise, contention becomes unsustainable in view of legislative effect of the statute.
another secondary ground is in para air. So far the limitation.
Limitation.
Yes.
Harm.
Ground number R.
Did you take up that contention in your counter?
Limitation.
Limitation is always treated by the apex court as mixed question of law and facts. Therefore, there has to be contention. Otherwise, not. Did you take up that contention in your counter? Reply.
No.
What is all in
No.
notary?
2-page counter, my lord. 2-page counter.
That doesn't exist.
You cannot improve. You cannot improve your stand before the tribunal. Your stand here.
That is the secondary ground.
That
So far the
cannot be.
limitation is concerned because the statute provides as such.
The contention as to limitation taken up in ground R. Is it R?
Yes, sir.
Yes.
R of the counter of the appeal memo would not be tenable. Such a contention having not been taken up before the tribunal in the pleadings filed by the petitioner state.
Mixed question.
Mixed question of law. It cannot be. If it is pure question of law, anywhere you can take up.
21 provides itself.
21 provides. See, Section 3 of the Limitation Act, read it. The court shall dismiss a time-barred suit.
Order 11 rule 7.
Order 11.
Order 7 rule 11 of CPC. It is not applicable to you.
But 21
To ascertain that, pleading has to be there.
But 21 of the Act itself says it could not have been granted relief in 2006. That was after 10 years.
Read 21. You are in writ petition. You are in writ petition. You should have taken up that contention so that we would have had the advantage of tribunal's view. We cannot invent a view which the tribunal did not do, having not been called upon. Yes, we
Because
take a
it is
tribunal
after
sentence.
10 years.
That's even this week. Take our own book. Take that. Apex court say limitation. Apex court in one judgment. Apex court said section 21. It is perhaps 21 of the Tribunal Act. Administrative Tribunal
21.
Ordinarily, Apex court said limitation prescribed under section 21 is an ordinary rule of limitation, and tribunal has abundant power to grant relief even when belated claim comes before it.
Here, my lord, 21 says,
Read.
in case where a final order such as is mentioned in clause A of section 20 has made in connection with the grievance unless the application is made within 1 year from the date on which such final order has been made. B. In a case where an appeal or representation such as is mentioned in clause B subsection 2 and section 20 has been made and a period of 6 months.
That is totally 1 year, 6 months.
1 year, 6 months.
Yes.
And such final order having been made within 1 year from the date of expiry of the said period of 6 months.
Yes.
That means 1 year, 6 months.
Yes.
Here, my lord, after 10 years.
No, further you read. There is power.
Yes, notwithstanding anything. Contradicted in subsection 1. The grievance in respect of which an application is made had arisen by reasons of any order made at any time during the period of 3 years immediately preceding it on which the jurisdiction power and the tribunal become exercisable under this act in respect of the matter to which such order relates, and no proceeding for this redressal of such grievances had been commenced before the said date before any High Court.
No, not that. There is power. There is judgment of the Apex Court, which said the tribunal has got power to condone delay on par with the writ court, because tribunal is a substitute in a way for the writ jurisdiction. I think SP Sampath Kumar. And 97 Supreme Court, which is a G. Chandra, no, Chandra, L. Chandra.
That is
L. Chandra.
L. Chandra.
Correct. Mr. Mahanti submits next point that the tribunal grossly erred in granting relief to OP number 1, ignoring the long lapse of time and enormous delay and latches. Enormous delay. First time. When asked as to whether such a contention was taken up in the pleadings before the tribunal, he fairly concedes that it was not. First time. Learned counsel appearing for the OP1 also points out that there was no such contention taken before the tribunal. First time. It is a settled position of law, subject to all just exceptions, that the question of limitation is a mixed question of law and facts, and therefore a plea needs to be taken up for being considered a statutory tribunal. First time. If such a plea was not taken up before the tribunal, for the first time, it cannot be taken up before the court without seeking leave of the court by an appropriate application for taking the same up. Maybe seeking leave to amend the pleadings before the tribunal itself. That they have not done. Sometimes they appeal amendment of pleading.
These are the salient grounds.
We will come to the opponents. We'll come to you, not now. Now, who is supporting Mr. Mohanty?
No, we are just challenging that since the tribunal held that there is a separate cadre, that much we have challenged.
You have challenged it in your WP.
Yes,
Which is that WP? Which is your WP? Is there any other WP with this?
6749 and
4 WPs are there, madam.
Huh?
4
Four
WPs.
WPs.
6748.
One is of the government. Two are government. One review, another is main order.
No. 2 different OPs.
Two different OPs.
Madam.
Verbatim or by
Yes.
two different.
6748 and 6748.
Common order.
49.
Common order.
Yes.
No, madam.
Separate order.
This is the leading and this is the...
The others are that this
Followed.
becomes the lead judgment. They followed it in another matter.
Not better. That is 7820. That was the last one.
In your WP.
Yes.
What you want to say? How tribunal has held according to you?
Our claim before the tribunal, there was no such cadre of binary-ration. And the tribunal held that binary-ration is separate cadre.
Because the legislation says.
Because our case was that it was with the water resource department and became one department. There is no creation of further cadre by the government. Only by virtue of that legislation and the list, that cadre has been considered.
Yes. Right. Legislation is upheld by the apex court.
But our case was that Supreme Court upheld, so far as regularization concerned.
No.
So far as different cadres are concerned, that has not been dealt with the Supreme Court, by the Supreme Court.
No, because it is dealt with by the legislation.
Yes.
Go to schedule to the legislation.
Yes,
So your whole case is set up on a premise
yes.
that the legislation does not create any cadre at all.
Yes.
But it has created a blind man can see. If you bring from a blind man from the Cuttack market, he also can see that the legislation has created it.
Yes, that was challenged before the court. And initially that was set aside.
Now all this question is because of apex court judgment. Learned counsel Shri so and so appearing for the companion writ petitions 3748 and 3749. 6749 submits that the apparent error in the tribunal's order, original order, and also review order. You are not putting challenge the review order.
The
Original order.
They challenge the separate judgment.
Separate way.
Separate judgment which followed the lead judgment.
Yes.
No.
No.
7820 and 6831 are same. Followed 7820 followed to 6831 judgment. Their cases is, my lord. After that, 866 of 2004.
866 of 2004.
191 C of 2004. And another two paragraphs. That was dismissed. That minor irrigation is, their claim that minor is a separate cadre. Tribunal hold that now it is a separate cadre. That there is no such cadre. Hold that is a separate cadre.
They registered that the tribunal had the same cards and this one, yes.
What have you done? Counsel appearing for the petitioners in companion writ petition numbers
6749 and 6748.
No, don't submit that. Submits that. The tribunal's impugned order, there are two orders. One order. Impugned order dated 15
29 2018.
Right?
20th of September 2018.
Wait, 34.
No. That is
Dated 20th
September 2018.
2018. In way number
866 2004. 081931C of 2004 and OA1990C of 2016.
Proceeds on the premise that there was a separate cadre of minor irrigation.
Yes.
Of minor irrigation. which is wrong. First off, had been no separate cadre, as urged by the petitioners, the tribunal would not have made the order of the kind, impugned order of the kind. Impugned order of the kind. First off, that constitutes a gross error apparent on the face of the record, warranting interference of this court in that jurisdiction. First off, into bracket one said, these petitioners have not, do not say anything about the validity or otherwise of a review order of the tribunal that is put in challenge by the state in WP number
6831 of 2019.
And the original order is?
Original, yes, also original order they challenged.
No, separate with petition.
134 of 2007.
That is 134 of 2007.
Anything more anybody wants to say? Brother, just we want to have a word from you also. Yes, please come. What is your view? Going by whatever we have yesterday, today, we have seen the papers, we have heard you also, heard the bar members.
My humble submission I have brought, given my judgment.
And don't be a partisan.
No, my lord.
Just say whatever.
While taking the view, my lords, according to my lord's view, that your lordship can also consider the stand observation findings rendered by the Honorable Appeals Court in
paragraph 81.
Paragraph 31 also, my lord.
31 also?
Yes, my lord. Because paragraph 31 says the regarding validity of Validation Act. Narrated the my lord.
Now, one question is, once the Validation Act is held to be valid, then the act has to be given full effect.
My lord, in that aspect, my lord is absolutely right. There is nothing to be, my lord, questioning them. Here is a case. The Supreme Court categorically held that it is not a true legislation. Here, legislature, the executive has surrendered before the legislature to regularize the form and method of regularization. The para 30 onward, 31, 32, 33, 34, clarified regulation and Honorable Appeals Court to accept that this is not a true legislation. It is the only method of regularization because the legislature has not violated anything. Only regularizes service those who are appointed as per the policy decision of the state, substantial period holding substantive vacancy. Therefore, the seniority, everything has to be done. And while considering the other aspect, other view regarding what both my friends are arguing their respective claim, that is the issue as per the para 82(1). Yes, my lord.
That is kept open for consideration.
Therefore, my humble submission that lordship also my view, I am not supporting anyone. It may not be a true legislation, Validation Act. Therefore, the schedule given, because department-wise there is mention. The schedule, Water Resources Department, or the original irrigation power as per the government rules, then Works Department, Urban Department. 3 department employees, stipend engineers are appointed in the different cadre, as the same cadre, same post, as per the Orissa Service of Engineering rules. The rule cadre has been strength defined as per the rule 4 of the 1941 rule.
No, that's all right. But our question, our question to you is, in deciding whether a legislation is valid or not, generally 3-4 parameters are there. The first one is, under Article 246 to 254, whether there is legislative power. That is there. That cannot be, because service conditions of the state employees is with the state government. So naturally will be with the state.
Yes, ma'am.
So that we cannot deny.
That number 2. The observation made para 30, the 4 paragraphs. So let's go through the
paragraph
30, 31, 32, 33.
30, 31, 32, 36. And 79, 80, 81,
my lord, 82.2 and 82.3.
29, 80, 82.2.
And 82.3 also, because
82.3.
these issue relating to minor irrigation, issue that is
dealt with in that particular paragraph.
82.3, that are set aside and governed by this order.
Okay. All.
Public.
Thank you.
He was the
Anybody wants to say anything? Do you want to say anything?
My Lord, I'm giving the date chart chronology of events relating to cases filed by the opponents, my Lord. Because
Third result. Mostly judgment tomorrow.
obligement.
Item 34, WS 624 of 2025.
Yes, with due apology, my lord. 24.
My lord, it's a recruitment to the post of Anganwadi.
Use of the mic. Voice should be heard. Louder the voice, greater the justice. Yes.
I'm trying to because I am little lawyer. My lord, there was a recruitment to the post of Anganwadi worker.
Why we have called officer?
My lord, officer, because there was an order passed by the passed in the writ appeal. But instead of continuing the appellant, my lord, that other men was, other women was continued.
Why, brother? Why it happened?
Sir, what happened on 17th March, on the basis of the order of Hon'Ble High Court.
When the order was made?
Order was made.
WPC of 29753 of 24.
WPC
29753 of 24, 2024. The Honorable Court had given direction to the selection committee to consider the petitioner's candidature in light of the clarification issued by the government. And in the clarification that has been issued by the government.
We'll give one option to you now. There is violation of the court order. Instead, we taking some action against you and damaging your service career, etc. We give an option to you. Can you retrace your steps?
Sir, we have already discussed this matter, and yesterday only we have initiated the proceeding of the selection committee, and by tomorrow it will be finalized in compliance with the Honorable Court's office.
Tomorrow it will
Yes,
be.
but I don't have objections.
With that, if that is done, then we will observe that and dispose of in the event that proceedings go against you. Whoever, he can challenge it.
No, my lord. No, it is not that.
Not that.
Your lordship had on
Can be seated.
24,
Sit down.
24/3/2025 passed an interim order staying the order passed by the Honorable Single Judge. That in compliance to the Single Judge's order, my lord, they have implemented. Now, because of the interim order passed by the division bench, they have to implement the restored back to the position, my lord, by driving out from the position of the.
No, we are telling you, they too are the stakeholders actually.
Yes.
They are agreeable with this proposition that fresh proceedings are being undertaken in the light of interim order.
My lord.
And whoever will be aggrieved by that,
He will come.
he will come before the court.
Yes, may say because my senior is not there. Your senior, the personal affairs may be dispensed with. Let them comply with lordship's order. It may be fixed to some other day that proposal can be given to my in his presence, order can be passed.
By our order dated so and so, 24/3/20, no. So that order.
That is order dated 24/3/2020.
Oh, this order, your lordship
Yeah,
passed this day before yesterday.
9/3/2026. We had said as at the next one. This day, a learned AGA Mr. G, assisted by what's your name?
Saurav Chakravarti, sub-collector.
Saurav Chakravarti. You are sub-collector, who is personally present before the court.
Bhadrak.
Who is personally present before the court. submits that the steps are being taken on a war footing to abide by letter and spirit of interim order dated
24th March 2025.
24/3/2025. 25. First off. They also assure that this would materialize within a period of 1 week. We'll say 1 week. Within a period of 1 week. First off. With this proposal, learned advocates appearing for the private parties are also agreeable, without prejudice to their intentions in the main matter. First off, in view of the above, call this matter in the third week of April 2026. First off, the presence of official is noted and his further presence is dispensed with. Okay. Yes.
Item number 2,
Thank you.
WBC 30567/2025.
Dispense with a warning that just not keeping the words would be viewed very seriously, and the contempt action may be taken against the officials concerned. Yes.
Item number 2, may I please?
Mr. Monty, why you are not seen on our court?
I'm sorry. I'm sorry.
Yes.
My lord,
adjourned probably.
my lord,
Adjourned probably.
my lord, I'm there at the bottom of the list. So, my lord, I'm coming, but sorry, my lord. My lord, here is a case which rests on a very small compass. The case is resting on a very small compass, but the order of the Honorable Tribunal, Central Administrative Tribunal, dated 24/9/2025 in OA number 634 of 2019 is under challenge. My lord, why I said it is on a small compass, the point for your lordship's consideration is when the original order has been quashed by the tribunal upon subordinate bench. Original order has been quashed, and against that, the respondents had preferred an appeal before this honorable court, where this
Appeal or writ petition?
Writ petition. That is what I said of this. Sorry, my lord. Before this honorable court, where no interim order has been granted, staying operation of the order of the tribunal, can the very original order, which was already quashed by the tribunal, be extended further, taking the plea that the appeal is pending?
No.
That is what has been done.
Will issue notice.
My lord, my lord, what
Have to be heard now.
yes, my lord. My lord, that is the entire case.
Understood.
Only
There is a maxim, do you know?
my lord.
Ex nihilo nihil fit. Out of nothing, nothing comes out.
Exactly.
Which Broom's legal maxims discusses.
Yes, my lord. That was,
Mr. Mohanty appearing for the petitioner employee. First of the case is made out for issuance of notice. First of issue notice. Learned the senior panel counsel Shri so accepts notice for OP number 1.
4.
Only 4. Alien of India.
Yes.
OP 1.
OP number 1.
Why 2?
1. OP number 1.
OP 1. OP 1 is UI.
Yes.
All the benefits.
That is
all standard.
Matter lies in a very narrow compass. Call this after 3 weeks. Okay.
Yeah.
See, that's the only point. If already it is quashed, when the question of tampering with that. Yes.
Yeah.
And can I pray with your lordship, my lord? Since my retirement date is approaching, I am still continuing under suspension. That is the entire case. So your lordship,
when are you retiring?
My lord, I am retiring in the month of August.
August. Before that we will do.
My lord, your lordship, fix a date so that it can.
It will come.
Fix a date. Oh, bless me.
It can be.
My lord, I will be doing injustice to your lordship, my lord, if I will not bring it to your lordship's notice. The last order passed by this honorable court, where I was called upon to bring the things before the tribunal on record, that have already brought. That is there at amendment. By way of amendment, that is fact A. So your lordship may allow that so that I can file the consolidated and I'll solve that.
Learned counsel appearing for the petitioner draws our attention to the year number so and so supported
At flag A.
Yes, for placing on record
236 of 2020.
seeking you to place on record the pleadings and documents before the tribunal, filed before the tribunal.
Yes.
In terms of
Last order passed.
coordinate bench order or our order?
No, coordinate bench.
Coordinate bench order. Dated?
When was the last order?
22/12/2025. Firstly, the application is allowed and leave as sought for is accorded. First up, the pleadings and documents produced. Documents are also
Yes.
produced along with them or taken on record. Yes.
Item number 3, WBC 3625 of 2026. The please your lordship on Mr. Mahanti. That's the matter, my lord.
Yes.
Then, my lord, admittedly, the petitioner is the defaulter. He has taken
Your
a loan.
voice and case both appear to be weak.
Yes.
Come on the mic and mic, make use of the mic.
Right.
Grab it.
So if at all you have defaulted anywhere, be a defaulter, but
Use the mic.
I'm sorry.
Yes.
In fact,
See, many students, law teachers, and public spirited people in the court hall, in every court. Therefore, our court also, we presume that they want to hear your voice more than our sound.
When we are watching online, more are watching
More
online.
people will be watching now. Therefore, every people will be assessing you. You are advertising yourself now with this.
Yes.
Be louder.
Yes. In 2015, we allowed avail the loan. Could not pay
2015.
15 law.
How much you have availed?
Availed is 15 lakhs some odd amount, and till 2019, Milord, he was paying. This is a housing loan, Milord. And in fact, in 2021, it became NPA. Then now, Milord, it has come to abide Annexure 7, Milord. Your Lordship will look at page
14 lakhs,
20.
16,000.
14 lakhs.
14 lakhs.
40 lakhs. 4016 and 317.24.
Possession notice is issued.
Yes,
You are for the bank.
My lord, yes, my lord. No copy has been served on me.
Huh?
Today, my Lord friend has appeared, my Lord.
Huh.
So I am permitted to serve a coffee and
Huh.
Maybe
Then,
taken-
what serving copy all right?
Lot.
What about the debt serving?
My one is, whatever information was given to me, I'm sharing it. He has availed loan of 22 lakhs 50,000.
22 lakh 50,000.
50,000. And it has accrued to the tune of 75 lakhs, 60 lakhs, 75 lakhs, 60,000, 957, some order. And that NP has been declared 9 years back.
No, he says 2021.
21.
To my lord.
I have annexed page 21, my Lord. The notice issued by them. There they have said that it has NPA. Page 21.
No,
Page
which
22. Page 21. 21, that is the letter.
The 10th October 2017 was declared. I am sharing the information.
Yes.
And for the last 9 years, he has not taken any steps for
Not paid anything.
no money.
Last 9 years, not
9
paid
years.
anything.
And he has come forward for.
What is this?
That is why initially I was. because of the illness, Lord.
Yes.
Yes, Lord.
What kind of illness it is? Which bacteria will remain in your body?
No, Lord. NHL 8 series given the certificate though.
What certificate?
The medical documents.
So you
And
will take them.
admittedly, my Lord, he is a defaulter. I am admitting that, my Lord. Now I only request my Lord friend. So you will file a one-time OTS application, my Lord, before the housing that LIC.
You can do that.
No, my lord.
Within
At this stage, my lord, it would be.
Possession is taken now.
No, my Lord.
We have taken the permission, my lord.
Possession you have taken.
No.
Yes, we have taken the permission.
14.
DM permission we have obtained.
Permission. What permission?
DM permission for taking physical possession.
We are asking
That is
you.
there.
Have you taken possession?
No, ma'am.
Simple.
It's a housing loan.
Yes, ma'am.
Yes.
Have you taken possession?
No, ma'am.
As on today taken.
No.
You give him 4 weeks.
Oh, my
If
lord.
he does not do, take possession. We will give order now. So that instead of going under 14, other things will be over.
My lord, 4 weeks subjected entire amount to be given.
How entire amount?
My lord, I am.
He will give some amount. You pocket
Then,
it
my
thereafter.
lord, my lord, allow me to go through the copy of the writ
You
petition,
come.
and I'll got
Call next week. So and so bank panel advocate appears for the OPs.
because his date of NPA and my date of NPA is differing.
You want to seek instructions. You say 10/2017.
Yes.
NPA date. He says 2021, referring to some order. Anyway, just look into it and come back. Even if it is 21, more than 4 years are over. Let us see. Therefore, I say, we said, this is a housing law. Suppose if you wait for 1 more month, you have nothing to lose because interest also will be paid. But entire payment, whole repayment is very difficult.
We lost hope of
Getting that also. That's therefore last chance is given to them. In terms of that, can you make
Yes.
an order? In the event they do not do, it is open to you to take all actions.
Yes, my lord.
Okay. Right. Petitioner, borrower is knocking at the doors of Red Court for assailing the coercive action of recovery by the OPs in terms of Surface Act 2000. First up, we are told at the bar that presently the petitioner owes an outstanding loan of rupees.
It has become 75 lakhs.
75,60,957. And that the petitioner has not serviced the debt since last 9 years or so.
9 years.
First of all. Next paragraph. Counsel for the petitioner, having argued the matter vociferously, now submits that his claim to the an OTS application which may be considered by the bank in terms of extant RBI guidelines and bank circulars. First, learned panel counsel appearing for the bank vehemently opposed the petition, contending that the petitioner is an unscrupulous borrower and therefore no mercy should be shown in the light of decision of Apex Court in Bhopna.
And M. Rajendran also.
Give the judgment. Next part, having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited reprieve.
My lord, no. Sorry, my lord. Is a copy be served on me, then pass on.
This is very innocuous order. Petitioner having the parties and having perused the petition papers, we are inclined to grant a very limited reprieve. If that the petitioner may move an OTS application within 1 week, along with the required requisite deposit, and that the bank shall, if so moved, consider the said proposal within an outer limit of 3 weeks. 3 weeks, full stop. All contentions in that regard are kept open. Till consideration takes place and result thereof is conveyed to the petitioner, no coercive action shall be taken. No course. Please go down. Next.
Item 4, WPC 4805/2026.
Yes, Mr. Buddy.
Is the file against Postal where copy deeds are not
Copy they are not-
collected?
Who appears for the petitioner?
Council name is
Call this matter after 2 weeks to enable counsel for the petitioner to come and argue. Next.
Item 5, WPC 5920/2026.
Yes.
I have challenged the order of tribunal.
Your voice is not audible to us. We are fed up of saying all this again and again. Lawyer should have a good voice. Yes.
My lord, I have challenged the order of the Learned Tribunal passed in way number 338 of 2020.
What is the
That is
defect
that-
in that?
My lord, while deciding this matter, my lord, the Learned Tribunal has not taken into the facts and also settled position of law in entirety, my lord.
What was the case before the tribunal?
Case, Your Lordship, this is the date chart, Your Lordship.
Apex Court, they have followed Apex Court decision in Secretary to Government in the Swami,
That
where relaxation cannot be claimed as a matter of.
Yes. I have also relied on the decision that is J.C. Jacob versus State of Haryana, my lord. And that decision was not taken into consideration. So also I relied on the decision of Commissioner of Karnataka Housing Board versus C. Mudaya, my lord. Here, my lord, what happened, my lord? In the year 2003, petitioner denied promotion to the post of LDC.
But you have been given LDC with retrospective effect from 5/3/2003.
Yes. That is during that period, my lord. My juniors, those who were promoted ignoring me, they got promotion to the post of senior assistant, senior tax assistant, senior tax assistant, inspector.
Are they tax department?
Yes. Excise
Department. So whatever has been granted to your juniors should be accorded to you is your case.
Yes.
Why tribunal said you are not entitled?
Tribunal said, my lord, earlier I filed, after my promotion, I submitted a representation to grant me promotion to the post of tax assistant. That was rejected. Against that, tribunal, my lord. Tribunal allowed that way, granting me promotion with effect from 2013.
2010.
13, my lord.
13.
My lord. Then, may I place the date chart? Your lordship will be clear.
3/5/2013.
My lord, the first case was decided on
Take
8/11.
notice, brother, my party requires consideration. Promotion. We cannot summarily reject and issue. I heard the counsel appearing for the petitioner. It is in mode of issuance of notice. Mr. Party accepts notice for OP numbers. All OPs. OP number 1 to 4.
And these two were proper opposite parties because they were the junior persons.
1 to 4 private opposition notice will go.
They are proper opposite against
Joint committee. So 5/6 notice has to go. We do not, if you want to give, as long as they are parties, we have to issue notice. If you give up, you will delete them at your risk.
No, they are
Just issue emergent notice to other OPs, returnable within 4 weeks. Okay. Keep this signed again, you can make use of that.
Item 6, WPC 6120/2024.
Along with Mr. Milan Kumar Eke.
Now we have requested only for issuance. Thereafter they will issue. Yes, next.
May I please, Lordship? The order dated 5/2/2026, that is at Annexure 8, page 137, passed by the DRAT, Kolkata, is under challenge matter.
What is the nature of loan? The nature of loan is housing loan.
It is a cash credit loan, my lord.
for business loan.
My lord. My lord, here, my lord, his application was allowed. That was challenged by the bank before the appellate tribunal. And the appellate tribunal, by the impugned order, has remanded the matter to the DRT for fresh consideration after taking two evidence into account, my lord.
Yes.
I am agreed by that order, my lord, on two grounds. I am the borrower.
What is the amount due?
My lord, they have sold it. Possession has been taken from me.
Auction has already been carried out, possession already given in.
Everything has gone from me. I am challenging the process they have followed. And the process.
What ground appellate tribunal said no?
The appellate tribunal remanded the matter for fresh consideration to allow them to adduce the notice under 8182 of the rules 2002.
Yes.
And the valuation department.
What is wrong with that?
Well, my submission is that tribunal is not permitted to remand the matters.
No power to remand at all.
Because the provision says that the tribunal can only modify the order, set aside, or the other may replace the provision.
How courts, various high courts in the country have interpreted that provision?
That, my lord.
That research should be done by whom? We cannot come to your house with all judgments and improve your quality of performance before us. See, when you read a provision, when you interpret a particular provision, already there are wise people who are dead and gone also. What they have said, what various high courts have said on these provisions. Where is the comparative jurisprudence in our high court? Absolutely zero. No comparative jurisprudence, no research. Coming to court as if you are coming to some good chowdhury. That will not help you. You will anger us.
This provision, my lord, I'll go for a research, my lord. But law is that.
Unless you do, you can't say law is that. Law is what various high courts have said. Just look into it and come back. Next week we'll have that.
Next week.
And you can give me a copy. I'll be able to process.
I'm right now.
Research. Why research is not being done at the bar? We do not see the research at all. Mr. Panda, what has happened to your bar?
In the Arbitration Act, Section 34, setting aside of the award is there.
Remanding is not there.
Apex Court has held that once it is setting aside, you have to set aside it. You cannot vary.
Remand. Because arbitrator is not there. But here tribunal continues. There the reasoning is, the arbitrator, once he passes the award, he goes away.
But the court held that Apex Court judgment by RF.
Remand is possible.
It is court power is only can set aside.
Not remand.
Note of Australian.
Recently, my lord, also of the Apex Court.
Provision is there to vary and modify. That is my suggestion is that it should be added to this statute.
Okay. Just look into that judgment also.
Recently, Hon'Ble Apex Court has said that if there is any illegality in the order, you pass the appropriate order instead of remanding.
Where is that order? That also you not brought here.
It is recently.
Call after 2 weeks.
Next week, my lord. Is my lord.
Next.
Item 7 has been adjourned. Item 8, WBC 707/2026.
Right.
May I please?
Yes, brother.
My lord, in this case, my lord, the present petitioner is only the residential part, my lord.
Yeah.
He has taken.
When the loan was taken?
My lord,
Housing loan or business loan?
Housing loan, my lord.
Housing loan.
Yeah, total amount is, my lord, 27,60,000, my lord. Total commitment is 180 month, my lord. But in the meantime,
1 second. 27.60 is the loan amount.
Yes, my lord.
Principal loan amount.
Principal amount.
When?
My lord, that will taken this loan, my lord, on dated 22/2016, my lord. Thereafter, my lord, 10 years already paid all the amount, my lord. 10 years, my lord.
10 years in installments. What is the monthly installment?
Monthly installment is, my lord. Total amount is, my lord.
Not monthly.
Monthly, EMI. Monthly EMI is, my lord. 28,000.
That is 28,739.
Yes, my lord. Yes, my lord.
28,739.
Per EMI, my lord. Now, default is, my lord, only 11 months, my lord. Due to the
11 months account from?
Account from the July 2025, my lord.
Since July you have not paid.
Yes, my lord. In the meantime, my lord, the 13-2 notice has not been served to the petitioner, my lord. But there is suppressing of this fact, my lord. They issued 13-4 notice, my lord. And what happened, my lord? The entire cost of amount is area, my lord, 5 lakhs. 20. Your lordship kindly Peru. The enter annexure 5 running page 24, my lord. Total amount is EMD
525.
525, my lord. And the cost of present value is, my lord, 8 lakhs. This flat, my lord.
But
due
outstanding is 5,24,000.
Yes, my lord.
You pay that, you will retain everything.
Yes. The total demand amount is 19 lakhs something.
No, now it is put to sale, auction now.
Already e-auction is done without any information, but possession not taken, my lord.
Possession is not taken.
Not taken. Your lordship kindly.
For what money it has been auctioned now?
90. Our area amount, my lord, auction is 52 lakhs 40,000.
But
that
your
is
outstanding recovery was
less
for
value,
19 lakhs 92,000.
19 lakh 92,920 years.
Yes, my lord. We're ready to pay some of the amount, my lord. Because my mother and my wife is residing here, my lord.
Issue. Have you made the auction buyer a party?
No, my lord.
But it has to be made a party. You appear for the bank.
Yes, my lord. On behalf of Amjan Kumar Biswa, instruction from the bank to appear.
Who is the auction buyer? Who is the auction purchaser? No knowledge. Issue emergent notice.
Copy to Biswa.
Learned panel counsel Sri so and so volunteers to appear for OPs. OP numbers 1 and 2.
Yes,
No.
1 and 2.
1 and 2.
Yes.
Emergent notice to other OPs. Next up, learned counsel for petitioner submits that the debt was serviced in July 2025 by remitting regular EMI at the rate of 28,739 rupees, 28,739 per stamp. Now, only a small sum of rupees 5 lakh plus is outstanding, which his client is ready and willing. Full stop. He also tells us that for such a small sum, auction would not have been effected. First stop. Further, he submits that auction has taken place. The occupation of the security property lies with the petitioner himself, and therefore the coercive action in furtherance of the auction needs to be interdicted pendent elite. First, he assures the court that his client would immediately remit a sum of rupees 5 lakh. 5 lakh. Today.
40,000 today. Tomorrow.
5 lakh.
40,000.
40,000 within 3 working days. First up. Next paragraph. In the above circumstances, application is favored and subject to petitioner remitting a sum of rupees 53 lakh. 5 lakh 25,000. 24,000.
Demand amount is now 19 lakh
92. But
now you
pay,
pay,
yes.
If that is so, then you pay 6.5 lakh.
Yes.
Subject to petitioner paying to the loan account a sum of rupees 6.5 lakh within 1 week. No, you said within 1 day only, you agreed that.
I plus tomorrow, man.
Within 2 weeks, as and rupees 3.3 lakh, 3.25 lakh within 3 days, and remainder within an outer limit of 2 weeks. Right?
Yes. In the meantime, stay of the possession, my lord, on that annex of 7, my lord.
The actions are stayed.
On dated 19/2/2025.
Yes. All further actions pursuant to action are stayed. Yes. Till next day, we call this matter
Urgent copy.
after 3 weeks. And delivery can do that. No? Yeah, they can be okay. Yes.
Item 9, WPC 7/11 of 2026.
The copy to be served.
Yes, sir, give copy. Brother,
yes,
you have to give copy and
my-
report to our court of action.
Yes.
Otherwise, don't print that order at all.
Yes, my lord. Now I have seen, sir, my lord.
Yeah.
Your Lordship, item number 9, my learned senior Mr. R.P. Kara is on his leg. So, subject to convenience of this bench, if the matter could be passed over to after lunch.
Item 10, WPC 7511 of 2026.
The petitioner had loan. Which was disbursed on 21st of October 2021.
How much?
That was 14 lakh 2,500.
14 lakh.
14 lakh, 14.
14 lakh?
2,500.
Housing loan.
Housing loan.
Yes.
Housing loan.
And that installment he was regularly paying, but from the year 2022, because of illness, he could not pay the installment regularly. That's for the arbitrarily no notice is on the 13/2 is received.
But property is auctioned already.
Well, no, not auction sale has not been done, but they have affixed a notice and put my house on
What
the
is the amount due according to them?
According to them, they are showing that the principal amount due is 12 lakhs. 12 lakhs 8,962. My application under another one, I'm sorry, madam, it is in the Oriya vernacular, madam.
Yes.
What is that? Proposal for, I have offered a proposal for one-time settlement, and since they have put my house under lock and key to release this. So I am ready to
You are
pay.
from the bank.
I am appearing for the bank, my lord. Whatever little instructions I have got, my lord, I left to your lordships. I filed my Vokalattam, it may kindly be taken on record.
No, he is ready to pay. Whatever installments that are already due.
I'll submitting that, my lord, the exact amount, my lord. When the loan is of the year 2021, as rightly said.
October 21.
21, my lord.
Correct.
And the loan is, my lord, loan against property. That means in the sense of a housing loan. Yes, madam. This 14 lakhs 2,500.
Correct.
And the second loan is mortgage insurance loan. That means the loan is more insured, and that was 20,530, my lord.
That loan.
20,530, my lord. So it comes to 14 lakhs 23,030, my lord. Both the loans, my lord. 14 lakhs 23,030, my lord. And the date of NPA is, my lord, 2/7/2024. And 13/2 notice was issued on 29/2024, my lord. And thereafter,
13/2 is
23/9/2024, my lord. And no representation received. So possession notice was issued on 22/1/2025, my lord.
22/1/2025.
22/1/2025, my lord. Thereafter, PM application, section 14 application was made before the district magistrate on 27/2/2025, my lord.
That is pending.
No, my lord. The order was issued on 23/5/2025, which was intimated to the petitioner by letters dated of the bank, my lord, 10/10/2025, my lord.
Section of 14 order is made on
23/5/2025, which was intimated to the petitioner, my lord.
Yeah.
By letter dated 10/10/2025, I have got the documents, my lord. I can produce, my lord. And on 13/1/2026, the physical possession has been taken, my lord.
Taken?
Yes, my lord.
13/1/26.
E-auction sale notice has not been issued. Possession, the
as on today, my lord, the action notice has not been issued.
All right.
The overdue amount, let me, my lord, that clarifies the inquiry my dear lordship is requiring. Overdue amount as on today is in respect both the loans, my lord, 3,53,278, my lord.
3,53,278.
Plus the cost of, my lord, taking over possession is around 2 lakhs, my lord.
2 lakhs.
My lord, my lord, the police itself takes 80,000, 90,000. I can give that breakup, my lord. Whatever instruction I have got, my lord, I am submitting. Or your lordship can say that whatever money he will approach the bank and the bank can calculate that. Not give the details of that, my lord.
No, let bank do.
Yes, my lord.
But again, we don't want to put the sheep at the hands of the wolf. Now we'll give the parameters. Within that parameters, you consider.
That's what I'm saying, my lord.
Yeah.
And
What
the
instead-
total debt, my lord, from today 16,14,340.
16
lakhs 12,341, my lord. The cost is getting position. That's it. That's it.
16, that will be 18 lakh.
My lord, your lordship can
Whatever
just
rates are
consider,
there.
my lord. Yes, my lordship, consider that.
It is very fair.
Well,
I don't dispute it. Only one thing is that so far the NPA is concerned, when your lordship will answer to...
Should not argue much in matters.
My
These are
lord.
all mercy petitions.
Yes, your lordship.
Arguments will spoil the mercy.
Because the...
Before the bank,
Yes.
offer the OTS or whatever you want to.
Yes. I have already offered. Again, I will offer.
Again, you offer. Just going filing one letter will not do.
Madam.
You should show by 30% of the amount you should deposit with the bank. Then they will consider your OTS, not otherwise. All right? Right.
And one additional small prayer. Since I will deposit 30% as your lordship, whatever as per lordship direction, everything. But all
once
my
they
deposit.
Once they deposit, you deliver back the possession.
The only, my lord, your lordship may ensure the bank's interest on the balancing act, my lord. Because, my lord, my friend has said that from 2022 they are not depositing, and now we are in 2026, my lord. Your lordship can ensure that, my lord.
That
This is correct also.
Yes, your lordship.
You will pay now.
Yes.
After payment of 30%, they will give the permissive occupation of the property, but possession will remain with the bank itself.
My lord.
Okay, you are only licensee in your property.
After clearance of the entire amount?
No, they will give back this one. Otherwise, all the exercise which they have done, that will be putting in this river.
That's good. Your lordship will only time frames.
Correct, man. Time frame, reasonable.
Deeply.
That's all. Kindly be seated. So fair and advocate. Petitioner has taken a housing loan and housing loan in October 2021 in a sum of rupees 14,02,500. First. Subsequently, he borrowed another sum of rupees 20,530
mortgage insurance
by way of mortgage insurance. And thus, in all,
14 lakhs 23,000.
A principal amount of rupees 14,23,030 is due. Is related to be due as on today.
No. And was availed.
As on the
Was availed.
As the principal amount. As the principal amount. First, the debt having not been serviced, the loan account came to be certified as NPA on 2/7/2024. Kindly be sit and answer. First, Section 13(2) notice followed on 23/9/2024. First, possession notice followed on 22 January 2025. First, Section 14 order was made on 23/5/2025. First, despite all this, no amount having been paid towards debt servicing, the bank possessed security property on 13/1/26. First off. Now we are told by the bank's panel counsel that a sum of rupees 16,12,341 is due and outstanding. Due and outstanding. Some more amount is spent for, some additional amount is spent for taking possession, etc. First off. Next paragraph. Counsel for the petitioner submits because of financial difficulty, the debt could not be serviced, and that now he is ready and willing to offer, make OTS offer by depositing 30% of the outstanding amount within 2 weeks. He also assures that he would make rest of the payment in terms of the OTS if accepted. Within a reasonable time as may be fixed by the bank. First off. He seeks possession of the property, saying that that is the only shelter availing to the family. First off. However, the panel counsel for the bank opposes the same, saying that petitioner is an unscrupulous borrower and therefore no mercy should be shown to him. First up, he also cites the decision of Apex Court in Bafna in support of his contention. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter to the effect that if the petitioner makes payment of 30% of the outstanding money within 2 weeks from this day, his OTS offer shall be considered by the bank, keeping in view the extent RBI guidelines and the bank's norms that are obtaining. Within a period of 4 weeks next following. First off, if the petitioner makes payment of 30% as undertaken before the court, he will be given permissive occupation of the property, the immediate possession remaining with the bank, continuing with the bank, so that it can deal with the property in any way it wants. Should the petitioner fail to comply with the assurance given here, first off, with the above observations, WP is disposed of. All contentions relating to OTS are kept open. No course. Next.
Item 11, RBWPET of 338 of 2023.
May I please, Your Lordship?
Yeah.
May I permitted to submit on behalf of Mr. L. Pradhan Miller.
Yes.
My Lord. The case, my Lord, the petitioner has filed the petition 1573 of 2013 to set aside the order passed in repetition number 4796 of 2012, because that order was obtained by fraud. And this Hon'Ble Court, by the Annexure 6, has given liberty to the petitioner to file a review petition. At Annexure 6. Thereafter, this review petition is filed, has been filed, my Lord. My Lord, the fact is like this, my Lord. Petitioner is the auction purchaser, my Lord. He has deposited the entire amount. Sale was confirmed, he has entire auction amount he has deposited, my Lord. Without impeding the auction purchaser, my Lord, the borrower came to this court, this Hon'Ble Court, my Lord, challenging the demand notice, my Lord. My Lord, there, my Lord, without impeding the part.
For first time it is.
Without
You will issue notice.
My Lord.
Issue emergent notice.
Limitation as well as
emergent notice, both on application and the main matter.
My Lord, is there for Eco Bank. Who?
Will you appear in this?
Well, I was not appeared in the.
Then let us see. Let it go. Let notice go and come back. Returnable within 3 weeks. But
My lord, may I pray, Lord, the guarantors may not be noticed.
notice to guarantors.
Guarantors are parties in the similar.
Whether you have made them parties, you have made them 5 and 6.
I have made the party because
yes, notice to them also.
Because they are parties in the representation.
Okay. Yes. Yes.
Item 12. Meet Appeal 786 of 2025.
Retired watchers employee not claiming pension.
Covered by judgment.
No.
Mr. G, Mr. Behra appears to be covered by the judgment. Delay of 201 days.
My lord.
Not so good.
No, not so.
We have already passed. So that is changes not really. Probably that's what this changes your to changes your to be made.
Well, it's only I pray 3 months instead of 3.
All right. Will you 3 months?
Well.
Instead of 3 months. See, wherever we have
3 months.
read this one, that you have to change. Yes, yes, follow me.
I may be excused, my lord. In item 8, I have instruction to appear. My associate is there. But there is a.
Item 8.
Your lordship passed an interim order. There, what happened? The property has been sold since 6 to 2025, and the sale certificate has been issued, and DM order has been obtained.
What order we have passed in there?
Your lordship passed the order to deposit some amount. But by the time a third party interest is created. So may I call the petitioner counsel?
It's called.
Because he has told that there has not been sold for that.
Yes, that's what he told us.
Yes, ma'am.
Yes, just call him also. After lunch, you bring him. Don't bring that. That item 8. Don't.
That is the fact, man.
All right.
Your lordship will pass the interim order. I have not started.
Suppose, see, we go by what the lawyers say. We have no reason to doubt them.
Yes, madam. My associate had told me that because I could not reach.
Yes, very well. Have you been here? That could not.
I am calling.
Other sub items.
All sub items also similarly have to change. Sub items delay is different and other things. All these things you have to do. Just after doing it, show it to. Let him show it to me. Yes. 13.
Item 13, date appeal 1907 and 25.
My lord, item 13 and 14, as similar matter have already been decided by your lordship.
Do that. Mr. Behra, just look into.
For a copy of
delay will condone. Delay will condone.
No, my lord. Your lordship has rejected the
delay application also.
Yes.
My lord, in this order, delay was not condoned.
In this order, delay was not condoned, and we have considered it on merits also. Same order.
My lord, I am the single.
That's this order. That's what.
My lord, I am giving.
In the earlier one, 3 months. Mr. 3 months. That you have to.
My lord, I am giving the corrected copy of 2 applications.
Yes, give that. Give that. Corrected copy. You give it that. 13, 14.
Item 13 and item 14, in both the matters, I have given the collected.
13, 14.
Yes.
This is one we have given.
Another is there.
Yes. No. 2 judgments.
One collected copy of item 13 and another, that is the collected copy of item 14.
14, okay.
That is 13.
Same order. 3 months for implementation.
In that previous order also, your lordship allowed 3 months.
3 months. Good. Next.
already mentioned in para 7, my lord.
You have mentioned
Para 7,
so what's the entry model we have made now?
Installment payment will pay at the time of pay.
But possession is already taken.
No. Possession has not been taken. DM order has been passed, madam.
Auction has been done.
Has been held,
E-auction.
certificate has been issued, and DM has passed order under section 14 of the Surface Act. That is the development.
You give the name of that buyer.
I have given the document, madam.
Commissioner to implead the auction buyer,
Lakshmidhara Panigrahi.
Mr. Arun Kumar.
No,
Arun Kumar Panigrahi. Arun Kumar Panigrahi.
Yes.
Son of Lakshmi.
Sorry, Arun Kumar Panigrahi, sir.
Yes,
son of Lakshmidhara Panigrahi.
Son of Lakshmidhar Panigrahi. Congress Office Lane, Shahid Park, Baleshwar Sadar, Mutiganj, Baleshwar, Odisha. As a OP number?
I have not mentioned because now
I have to do it now.
Sir, my lord. They are not communicate to us.
No. So now we have said
Giving a copy.
That's what.
OP number 5.
OP number 5 to the petition. What is the entry model we have said now?
The lordship directed to deposit the money 5 lakhs 40,000 total amount and another due amount, my lord. That will deposit.
Totally, how much is due?
Total due.
As per the letter,
19 lakhs.
19 lakhs some odd for and interest.
19 lakhs plus
some odd
interest.
and interest. The sale has been made on 15,000.
64 lakh 15,000.
So he has deposited the entire amount now.
Entire amount?
Yes, sale certificate has been issued thereafter.
Interesting fact, my lord. The cost of the value is 80 to 80 lakhs, my lord. By the convenience of there is suppressing
all this question is argument when you do not want to pay the money.
Yes,
prepaid all these questions.
Yes.
So I only bring the notice of this on court that a third party right has been created. That much only, nothing else.
You recall that order that you implead him.
Yes.
You take notice, emergent notice. Perhaps you have to make payment to that person. If he agrees, we can grant relief to you, not otherwise. Because you have seen Bafna. You take emergent notice.
Now, in the meantime, no action has been taken because
issue emergent notice. The learned panel counsel Sri points for appears for OP numbers 1 and 2.
Yes, ma'am.
1 and 2 alone. Yes, principal. 1 and 2. First of notice to R7, DRT is dispensed with. Emergent notice to the rest, including to the newly added OP. First up, call immediately after service of notice. Next paragraph. In the meanwhile, the auction shall not be confirmed.
Auction already confirmed, madam.
You have confirmed?
Yes, madam.
Possession not made.
In the meanwhile, the status quo.
Transfer of the property not made.
Status quo as to possession of the property would continue.
In letter dated 19/2/2020.
Now you take this.
Your lordship is directed to deposit that amount before this court or not?
No, not necessarily. Not because he has to agree.
Yeah.
Now he will deposit and tomorrow it does not happen. Why he should suffer? Anyway, you have a full amount that now.
No. Because third party right has been made.
That's all right. The auction money is with you now.
Yes.
Then why you should pay?
We will give on interest.
Let us see. Next.
If lordship's kind permission,
yes,
there was a misunderstanding between me and my junior lord for item number 9. I was requested him to make a mention for a Passover, but unfortunately he made it 2 weeks after.
We have signed the order sheet also.
I'll take my chance after 2 weeks.
Yes. Whether order sheet is signed?
So I'll take my chance after 2 weeks. Much obliged.
Well. Yes.
Item number 15, WPC 9735.
In fact, Mr. Carr, he did not mention your name also. Your colleague Did not mention your name also.
Maybe out of anxiety, my lord.
Maybe. Yeah, is there any urgency?
My lord, it's only a limited prayer, my lord, for restoration of a essay appealed by the tribunal, my lord. What happened, my lord? The poor lady, my lord, she became a widow.
See, that order is not uploaded. Sir, call that. Call this matter. Next week you can do
Next week.
You put it next week. So, yes.
There's a limited prayer for restoration.
That's what.
That is
Let
it.
us.
Much obliged.
Item 15.
Item number 15.
15.
Millards 15, there is a issue, Millards. Millards, I'm filing an affidavit as to steps taken. I'm not able to trace the address of the occupant number 4A, with the son of the occupant number 3. My learned friend is representing him. I am not able to trace his present address. He's in the US. It's a present address. The permanent address is in Jajpur, in Orissa. So we have gone to the local police. They said that they don't have any address. We then went to...
You furnish address?
Yes.
There is a dispute between for the last occasion.
Between you and son also?
Son and the
This is
father.
created for the bank issue. It's created for the bank issue.
One second. After death of the mother, father remarried. For that reason, there is a dispute and he has went to USA and stayed there. He is not returning back till now also. In prosecuting his study.
Even address is not available?
No, my lord. In which...
We'll direct
Your lordship
foreign office to give his full direction.
consular service for that reason. Your lordship is director for consular service.
We have approached the Passport Seva Kendra in Bhubaneswar. They said we cannot give any information unless a specific direction is given to the MEA, Ministry of External Affairs, to produce the address. Ministry of External Affairs will consult the Consular General of India in USA and then give the exact address.
We'll direct them.
Yes, Lord, say per direction will pass, then we can immediately approach to Passport Seva Kendra.
Counsel for the petitioner submits that the correct address and credentials of OP number
4A. We have solved him via email. That is there, but I don't want to. I have to give a service hard copy. Better, it will be better.
4A are not available, and therefore the Ministry of External Affairs be directed to secure the same from the Indian consul at US,
Consul General.
US
Consular General.
Consular General.
Yes, ma'am.
You say consul.
Millards may use him.
Office
He will.
at US. First one. We agree with this. First one. Next one. In the above circumstances, the Secretary, Department of External Affairs.
Ministry of
External Affairs, Ministry of External Affairs, New Delhi is directed to secure full and correct address of OP number 4A, meter, so and so, right, full address, whatever. And furnish the same in a sealed cover to this court within an outer limit of 4 weeks. Yes. 4 weeks. First, registry to send a copy of this order to the Secretary Service by speed post immediately. For ease of reference, the email address of OP number 4A is furnished below. Yes.
Affidavit
is also furnished below. Okay, just right now. Let them. Petitioner to pay a sum of ₹1,000 to the registry towards expenditure of this.
Page 15, mail Page 15.
Post immediately after service. No, after 4 weeks you have given, na? You can post this matter in the third week of April.
Minutes may pray with kindness. One date may fix, but MEA will also see the date. The date, minutes, kindness, I
All
pray.
right. Put this matter on some date, give one date.
Yes, any date. I leave it to Millers.
12, 4, 16.
16th. Much of it, much.
Yes.
Much of it, much of it.
Yes.
Item 16, WBC 27313 of 2017.
May I please? And here in this case, the petitioner challenged the order of the Honorable State Administrative Tribunal where the petitioner was appointed in the year 2019.
What was your grievance there before the tribunal?
Given for regularization.
Regularization.
On the
How
ground
many
that-
years of service you have put in?
On the ground that my juniors
Are regularized?
are regularized. On that ground, I approached this the Honorable Tribunal, and the Honorable Tribunal has directed to make a representation which shall be considered accordingly.
Yeah.
And my representation was rejected.
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 Against
Thereafter,
that you went to tribunal.
my lord,
Against rejection you went to tribunal.
again we went to tribunal. There the tribunal, after hearing, dispose of the case to verify whether the petitioner is indeed senior to the other persons or not. If seniors, they are regularized notionally. That order was also challenged by the state before the Honorable High Court mandate. It was confirmed. The WPC was rejected.
Yes.
In spite of that, again they have rejected my representation.
On the ground
Both
that
tribunal-
no senior.
My lord.
Any juniors of you were given regularization?
My lord. During the year 1999.
99.
My lord.
You gained entry when? On which date?
I have entered in my on 7/2/96 on daily wages basis.
Are you working even today?
For some times I will. Now I am again in 2010. I have been engaged on the daily wages basis.
Re-engaged?
Re-engaged on daily wages basis.
How long absent?
99 to 2000, during that I have approached this court and tribunal.
99?
From 99 to 2010.
2010?
Mile.
10 years?
10.
11 years. During that period, not in service?
Not in service. Your Lordship, I may want to, Your Lordship may see the compilation of documents I have filed at flag 10.
There was no further engagement or order after 13/7/99?
99. Because I have approached this tribunal, thereafter again tribunal, High Court, I am running from court to court.
But where is the continuous service?
Continuous 2010, again I have been engaged.
From 2010 to?
Till now I am continuing.
Now you are continuing or you have retired?
Continuing.
Where is it true? Is it continuing?
My lord, that instruction I do not have.
You get that information?
My lord.
Lordship, only I want to show the order of the...
Actually, it is work for 89 days. After that, there was no...
No, but thereafter...
No, it's not.
In 2010,
he says he has been continuing.
I will take instruction.
Just verify.
My lord.
Lordship, he said that because since 2099 he is running man.
Counsel for the petitioner submits that his client has been re-engaged with effect from which date?
My lord, I'm saying.
With effect from?
With effect from
4th February 2010.
With effect from 4/10/2010. And that he still continues in the engagement. First come. This fact needs to be ascertained by the learned AGA, Mr. Behura, and therefore call this matter after 3 weeks. After 2 weeks. After 2 weeks.
Fix a date, otherwise.
No, it will come. Most immediately thereafter.
Can I place one thing? The Lordship may see order dated 5/2/24, my lord.
5/2/24.
The Honorable Court has directed when the tribunal has allowed my original application, and which was confirmed by the Honorable High Court, why they have not regularized me? And to that effect, they have directed to file an affidavit. Since 5 to
Mr.
20.
Behera shall also make submission in respect of order dated 5/2/2024 passed by the coordinate bench in this case. Okay. Yes. Call this matter, you want some date, you want some statement. 7th of April. 7th of April. 7th of April. Yes.
Item 17, WPC 5146 of 2018.
May I please, Your Lordship?
Yes, sir.
This is a case, my lord, where the petition was the petitioner before the Supreme Court.
Make use of mic. Those who speak loudly, we appreciate them. When fistful marks are given.
My lord, the petitioner was one of the petitioners before the Supreme Court of India, where the Supreme Court had passed an order in our favor. There are 204 petitioners before the Supreme Court. That regarding the fixation, restructuring, they have wrongly implemented the order of the apex court for which contempt application was filed. Contempt court had specifically directed that the after placement, then promotion, my lord. They have not implemented, my lord. But pursuant to Supreme Court direction, the CPO has specifically said that there is no option than to treat all these petitioners to fix at 550 in deputy scale, deputy superintendent. That order was complied in various divisions, Bilaspur and Chakradharpur. But in Odisha, Valtier division and Khordha division, they have not implemented, for which he has filed a
So
case.
they have to implement the order dated 14/5/93.
My lord.
Of the apex court.
Yes, my lord. Thereafter, he has approached this court tribunal, praying that the order of the apex court as well as apex court be implemented and their pay should have been fixed. Case was allowed. Subsequently, I have filed a contempt application. Contempt application was dismissed. And in contempt petition, they have filed an reply stating that the order will be implemented. Subsequently, they have said that the order has been implemented in 90. How a 93 order has been implemented in 90, for which he has filed a criminal contempt. Thereafter, both the case has been dismissed. Then he approached this court in contempt. This court has said that the writ application is not maintainable. Thereafter, he approached the Supreme Court, and Your Lordship, Supreme Court specifically directed that I am reading the order.
Remitted back to this court?
No, tribunal, stating therein that we may make it clear that this liberty is not to be given avail by way of contempt, but by way of an fresh original application. Supreme Court said that you give the specific fixation. That is, I am reading, my lord. Therefore, leaving the question of law as to the maintainability of the appeal before the High Court, these special leave petitions are disposed of a liberty to the petitioner to make a specific prayer before the tribunal as to which part of the order dated ethically has not been complied with by the railway administration, in which case the tribunal look into the original proceeding and take an appropriate action to see that the order original passed by the tribunal dated ethically is properly complied with letter and spirit. But liberty has been given not to file a contempt, but to file an. Thereafter, he has approached this tribunal. Tribunal dismissed this case on the ground that they have approached the tribunal in late, and also you are watching just a page, the last line, my lord.
When apex court order was made?
93, 14/5/93.
When you approached the tribunal?
My lord?
When did you go to the tribunal with that order?
After that, he approached because...
When?
My lord. In 99. 99 before the Calcutta. before the Calcutta bench, Central Audit Tribunal, Calcutta bench, because the
when did you?
Were number 549 of 99.
99.
My lord.
The order was in 93 and you was in 99. Where number?
Were number 549 of 99.
549 of 99. 549.
549 of 99.
Of 99.
That is, I have mentioned in my date chart also. You know.
Whether any delay is explained. Because Apex Court said it on 14/5/93.
Yes, my lord.
For more than 6 years.
Yes, ma'am.
You did not go before the tribunal at all.
My lord.
Then one fine day you woke up and went before the tribunal.
Because they have partly implemented. Suppose in 93 order, they have implemented it in other division in 95 or 96. That is why they expected that they will implement the order. That is why.
Have you said that or you are just arguing like that? Have you said in the petition? In your petition before. Have you explained the delay in the petition as to why you could not approach within 6 years? There is a delay of 6 years.
Yes, my lord.
Although Apex Court did not prescribe a limitation,
my lord.
It is not after 1 century you cannot go and say, Apex Court has said to my great-grandfather, and it has not prescribed any limitation. Therefore, I am as a great-grandchild, I am before the tribunal. That is not permissible.
My lord, okay. But
therefore,
I have to. Exactly, I cannot conclude. So thereafter, that has been transferred to Court of Bench.
No, you want the time.
For this extension, I have to go through that.
You have to explain that. All right. Call 2 weeks?
Well, only my submission before Lordship. The petitioner now here is 92 years. So, 2 weeks your Lordship may grant, but one date may fix. Otherwise, he will
call this matter at the request of learned counsel appearing for the petitioner. Call this matter on 15/4. 15/4, all right.
Well,
15th April.
Sorted. In this month, my lord?
In this month only?
Only. On 29th?
29 is Sunday. We can't sit on Sunday, unfortunately.
No,
we'll call this matter on
30th.
30th. 30th.
What? Yes.
All right.
Well.
30th.
My lord, yesterday saying that 30th may not available.
Any other benches, other judges will be here, na? Our court will not be closed if Dixit leaves.
Then my lord, your lordship may advance on. When your lordship will avail, not 30th.
Therefore, I said we can have it on 6th of April.
My lord.
Call 6th of April. Okay.
At 2 p.m., my lord.
2 p.m. Yes. 2 p.m. We'll put it in that way. You come at 2 p.m.
My lord.
We'll pass it over.
No, your lordship, this order that will be mentioned at 2 p.m., it will be taken up. Otherwise, I will be ready.
Are they?
That will be mentioned at 2 p.m.
Yes.
Item 18, WBC 6233 of 2018.
18 state is the opposite party. Mrs. Patnaik AGA is assigned this brief. So he is having some inconvenience today. May not maybe adjourn to next week.
Call week after next at the request of learned AG. Yes.
Item 19 and 20 have been adjourned. Item 21, WBC 14353 of 2022.
21, This pertains to employees who have been utilized by the Postal Department, my lord, for more than 6 to 9 years. And they are all perennial nature of work, my lord. That means they were sorters, they were moving mails, they were sorting mails, they were even parcels when they come, they did all that. Some of them worked in the computer, all of them continuously worked for that many years. But what happened? They changed the venue from that place to another place in Bhubaneswar, my lord, not anywhere else. When they went there, my lord, they didn't give them employment. And they took another set of people.
And 3 out of these people, my lord, were employed also.
My lord, not fair. 21 and 22, I'm praying for time. Because reading complete. Reading because part of the record, because record transport to us, some document will be given by department. So after next week, day or 6th or 7th.
It appears he comes from Delhi.
No, my lord,
Now he is in Odisha.
Now I am not in Odisha, my lord. I am 60% here, 40% there, my lord. I am when whichever date, my lord.
You tell 60% date will fall.
Whichever date, my lord. No, my lord, as long as it's
So
not.
you take whichever date. On that date, Mr. Padi, you don't ask again.
No.
You choose a date. You choose a date.
But 6, 7, 8.
Whichever date you want. That day, no adjournment again.
7th. 7th of February.
7th. This date is pulled down from the calendar by Mr. Padi himself. Okay. Finally. Yes.
Item 22 has been adjourned. Item 23.
Is it possible, my lord, to specify a time, my lord, if it's subject to pleasure of my lord? My lord, because they have been out of employment from 19.
No, what you want? No, we have fixed.
2 o'clock, my lord, 2 o'clock is possible. I'll be deeply obliged.
Yes.
Item 23, WBC 2114 of 2025.
Item 23. 23. Not to put in final count. Today we will filing the counter.
Today,
Search the copy to copy the
1 week granted to Mr. Padi to file counter.
Today we are filing, man.
We have given 1 week.
Yes.
We'll call it after.
Yes, ma'am.
Call next week. Yes.
Item 25 has been adjourned. Item 25, WBC 13639 of 2025.
Mr. Padi, you are there, no? 25, 26, both.
In this case, my lord, perhaps you should notice and they have filed the counter. They counter other side will file the counter.
Have you filed the counter? This tribunal matter, no?
Yes, sir.
Where is the question of counter? Tribunals matter. All whole set of papers of the tribunal will be here. Have you produced Mr. Padi? Have you produced all papers that were before the tribunal?
Yes. So we file the counter and here we are also petition before my lord.
Here also. Are you ready or not? Why?
I am not ready.
Not. You say that. When will you be ready? After 2 weeks?
After 2 weeks.
All right. 2 weeks at the request of both 25, 26.
26 is separate matter. 26 is another matter.
Are you ready?
The 26 is not our matter.
26 is also your matter, na?
Union Bank of India. Union Bank of India.
Oh, Union Bank of India. You are right. All right.
My lord,
You appear for 26.
I have 26, my lord. May I pass over, please? May I pass over? On behalf of Mr. Amyo Kumar Misra, may I pass over?
Pass over. Afternoon, what it is already 2:30. My brother has a meeting. He will be sitting. We will be here up to 3:45 alone.
Mr. Miss, here, what is the prayer made in the writ application is also the subject matter of prayer in the securitization appeal, which is pending before the DRT. So this is an abuse of the process of law. Same prayer, same set of facts.
No, but if suppose will you be happy, satisfied if direction is given to the DRT to dispose of your matter because you have duplicated the same prayer here.
Madam, sir, Mr. Misra, Mr. Misra, he is in of the matter. He is in other court.
Will pass over.
Pass over.
Pass over.
Item 27 has been adjourned. Item 28, Contempt 3744 of 2025.
This contempt petition, my lord.
What have you done?
My lord, these two contemptors, they are subordinate officials. Funds are not with them. Funds is to placed by the government for dispersal. Only that much affidavit, and they have forwardly moved before the government by repeated reminders that the Honorable Court is asking for compliance, and the government is laxity in the part of the OP number 1, that is the petition that the state. The state may be given it needs perhaps that to place the fund because that is worked out and the amount has been worked out only for placement of funds so that it can be disbursed of. Only that two contemptors. The petitioner chose the subordinate official to make opposite party belong. Anyway, we are a government at one wing, Milord, one organization. We are bound to by your lordship's order. Simple, my lord. But we want some time. But one petition we have filed some more of 15 days time, my lord.
When the order was made, 27/11/25, 27/11/25. No time will be granted. We'll direct their arrest and detention. Why for time? How can contempt court give time? Contempt duty of the contempt court is to take action against the violators, put them behind the bar. That is the jurisdiction we have.
But there is no intent to violate your laws.
No, order has to be implemented. See, two things. One, contempt is one thing. Contempt is meant for implementation of the order also.
Yes, we are seeking implement.
When are you going to implement? You give an undertaking.
That not we have filed an I.
Otherwise, what is that? Giving first contempt? We don't subscribe to that view.
That I 533/25.
We don't want Mr. Panda.
My lord,
are you going to implement the order or not?
We have in affidavit saying that we are going to implement.
When you are going to implement?
Lordship may grant out more time, my lord.
No, what is that? What you have said in your application, in your
application, my lord.
Otherwise, we will direct arrest and detention. That is the only way we know. That is the only language which the state government understands.
16,41,650 in favor of the superintending engineer Jarka. Irrigation is to be placed disbursement of the said amount to the petitioner. My lord, the specific respectful submitter soon after allotment of funds of the same shall be disposed of.
No.
We have sought for only 3 months time. 3 months time, you will also grant 15 days.
Wait, 15 days. Within 15 days, you will implement the order. You just file a memo. That within 15 days. Yes. We are disposing of this matter.
Of this IA, my lord, I undertake, and if it will not be complied, the contempt notes will be personally present before to explain. That your lordship may pass that on.
Who appears for the petitioners, the complainants?
Mr. Mahanti. Mr. Ranjit Mahanti.
Mr. Ranjit Mahanti. In the event it is not complied with, that will be an aggravated contempt.
Let them come personally and answer. Before I am embarrassed every time, my lord, that what can I do, my lord?
Correct. Right now. Mr. Panda, learned AGA appearing for the contemners, having drawn attention of the court to the affidavit.
IA number 533.
IA number
flag D.
533 of 2025, supported by the affidavit of one of the contemners.
Yes.
One of the contemners submits that the order of the court would be implemented within an outer limit of 15 days, reckoned from this day. First, in view of that assurance, call this matter. They say within 15 days they will implement the order. We'll call this after 15 days. Or we will dispose it off with liberty to revive it for aggravated contempt. Aggravated contempt. All right. That's good way. In view of the above assurance given, the contempt proceeding is dropped for the time being, with liberty to the complainants to seek its revival for aggravated contempt, should the assurance be not kept. First, ordered accordingly. Okay. All right. If they do not do, move a memo, will revive it and take action for aggravated contempt. They will do that. Generally, they will do that because that assurance they have given, they know our nature also. Yes.
Item 29, WBC 603 of 2020.
May I please? Item 29, I am for the one possible, one possible. Because of twice he has taken time. One is letter will not reach because I thrice I have waited, my lord.
What time you are, brother? Because
this is the
arguing counsel will come.
The only election number for the petition. One my lord, matter is going on. My lord.
You bring, okay? Next.
Item 30, WBC 3378 of 2026.
Lordship, I am for the petitioner in this matter. Lordship, I pray for 3 weeks time to file a rejoinder and objection to the interim application for vacation of state.
My lord, I have filed a petition. According to me, that is matter has been suppressed and placed in my absence. ex parte order of the interim order has been passed, when the outstanding is about 60 crores. We have given a possession notice. He has expressed that on his consent, not that we have given in that way. There is a document is there. He has given that consent that bank can proceed with the DRT and surfacing, because we have got an understanding with this. Accordingly, we have given a notice to him and to the corporate borrower and to the general public as a whole, that not to deal with the property in any manner whatsoever. That has been stated, my lord.
2 weeks, sir, you file objections.
Yeah, rejoinder along with her objection to the intervention application.
Huh.
3 weeks.
No, 3 weeks you do. Only 1 week will be given. Call next week, because fraud and other things.
2 weeks. No, there is no fraud, Your Honor.
He's saying, na?
No, he can say a lot of things. My senior can say a lot of things as per.
I can show documentary evidence.
Your Honor may see the first submission that the 62 crores is outstanding. Your Honor may see the 13-4 notice of the bank which has been listed.
Let us
at pay.
Call this matter after 2 weeks at the request of learned counsel appearing for the petitioner who seeks to file the rejoinder.
Rejoinder along with the objection to the intervention. Yeah.
Along with objections to the application in IA number so and so. Yes.
Interim order to continue.
Finally, interim order to continue for 2 weeks only. Yes.
Item 31, WBC 4060 of
My lords, I have defaulted in complying with your lordship's order, partly lordships. Lordships, when the order dated 25th February, lordships had directed me to deposit 5 crores, then 12 crores, my lords. On the specified date, my lords, I had put in 5 crores. But my lords,
5 crores?
I deposited on the specified date, that was within 2 days, my lords, 27 minutes. The rest part, lordship, I had difficulty. I am prepared, my lords, may extend my time. I am prepared to pay the interest, bank interest of the rest 12 crores, my lords, may give me some time, lordships. Because of... I filed an IA to that effect also.
Your lordship may pass whatever orders, may I just make my submissions. First is, my lords will see the order dated 26th February 2026, wherein your lordships were pleased to extend extreme grace by permitting the corporate debtor to deposit the amount, dehorse the IBC proceedings minutes. Your lordship will see the order dated 26th February. 25th February. May I just read para 4? Having heard learned counsel appearing for such and such, we are inclined to grant some reprieve to the petitioner inasmuch as they have agreed with the proposal of this court to show their bona fide by depositing 5 crores only on or before 27/2 and another sum of 12 crores only on or before 7th of March in the registry. As mentioned above, they are ready and willing to give some solatium to auction buyer as well. In the above circumstance, petitioner directed to array the auction buyer as OP number 3. That's
who appears for the auction
buyer? I am
appearing
today. And I have instructions to appeal for the OP number 3. And the last part of the order says failure to comply with the undertaking would entitle dismissal of the writ petition. Now, that being the case, they have deposited as has been...
Would entail dismissal of the writ petition.
Yes, now, they have
filed my IA on the 7th.
Indicate. I am sure what my submission is today. Your lordships have been pleased to give them some reprieve. Only thing that I wanted to submit before your lordships is that during the submission that was made on the last occasion, it was categorically argued before your lordships that they are willing to pay the entire amount within 7 days. So 25th February, the submission was made that they are willing to make the entire payment within 7 days. That would bring it to somewhere around first week of March. Today, we are in on the 11th of March. The second installment that your lordships directed, they have failed. That's my humble submission today. What under instructions from the bank is what my submission is. Your lordship may permit them to deposit the remaining amount. But insofar as the total auction, they are, will kindly see the additional affidavit.
Well, I do admit, I have said that I'll match the bid.
They at para 7, additional affidavit, para 7, page 5.
Yes, that's my affidavit, lordships.
Yes.
I don't want to argue on the affidavit I have submitted.
They are...
Only
the petitioner undertake that if any bid is finalized pursuant to the impugned auction process, they are prepared to match the same financial terms subject to reasonable timelines and safeguards as may be directed by the Honorable Court. Unless they are ready and willing to match the auction amount, that is 32.61 crores, that is bidded by the OP number 3. Now, Millets, my humble submission is the remaining, they have deposited 5 crores. Whatever is the remaining amount, let them deposit that amount into the liquidation account, because this is a liquidation process, and into the liquidation account within a reasonable period of around 10 days, considering this is the month of March, your lordships, they may deposit, and that is what my humble submission is. So your lordship will kindly consider my humble submissions before your lordships, insofar as considering it's for balancing the equities, because they themselves said on the last occasion, 7 days they are ready and willing to pay 32 crores. So that's what I'm continuing from where my learned senior friend Mr. Samantrai started. So I'm continuing from there only. The lordship may kindly direct that will give a quietus to the issue. That's my.
Well, may I submit? Well, I want first to comply with this order. That's why I have filed application for seeking extension. I am prepared to pay the interest also, my lords. But my lords, I am on life support with your lordship's grace.
No, but we are not.
We only required some time to comply this 12 crores, my lords.
5 crore you have paid.
Yes, madam.
12 crore you have not yet paid.
Not yet paid.
You deposited this 12 crore within how much time you need?
Well, at least till March year and this 31st March, my lords, I would require, because year-ending difficulties are there, my lords, practical difficulties.
But that difficulty was there when you made submission that you will make the payment.
But the person who was suggesting to come as the investor,
what they are saying, but their submission that day was within 7 days they'll make 32 crores payment.
My lords, that was made at that point of time, but subsequently I had taken instruction that we'll pay my lord said 17 crores. I said that 12 plus 5. But 5 we made instantly on the day after what was the order specified.
But all right, but remaining
12, my lords, may give me at least till 31st March, lords. With interest.
Auction buyer, what will you pay him? Why?
That's the interest. We will. The amount he has deposited, only 50 lakhs he deposited. Will service his interest at banking rates, my lords. I am prepared to take the responsible banking rates.
He participated in the auction not for getting the interest. It should be.
I leave it to your lordships. I leave it to lordships.
Last year, my lords, he will pay to me.
I leave it to your lordships.
The amount is not mentioned, my lords, in the order, in the last order which my senior read out.
Here, you should be ready to pay the solatium fee.
Solatium.
Because you have
50
participated.
lakhs that I have already deposited.
How much you have deposited?
50 lakhs, my lords.
50 lakhs.
EMD amount. Yes.
EMD amount.
Yes. And the day I was going to deposit 25% of the auction amount, my lords, your lordship was pleased to grant this only.
What is your expectation?
That regarding that, minutes, I have no instructions. Today morning, only received. I do not have the Wakalat Nama also, minutes. I'll file it. And regarding minutes, what my expectation and everything, I'll come back to your lordships on that.
Let them deposit that money with the whale.
Malats.
You deposit it the whale.
Well, if we had deposited the court registry account, my lords, the 5 crores, we'll also deposit 12 crores in that court registry account.
In the court registry?
Yes, we will deposit it also.
The liquidation account, which is governed.
Let it not go to the liquidation account, my lords, we will deposit the court account.
I'll tell you why.
My lords, then I will.
Now I'll tell you, what?
No, suppose if you lose the case,
my lords,
you want to take back that money.
No, my lords, I am not on that.
The matter should go to
as per the order,
my lords, I had NCLT as was earlier directed by your lordships in this scheme. Petitioner's own case, your lordship on the last occasion said that you go before the NCLT. Now, if they have grievance, if they have apprehensions that they will not make payment to the OL's account, the liquidator's account.
Anyway, they will be in the court only. That money, this now how much? 12 crore it is.
My lords.
No, 27 crores.
The compliance with the order.
Order is 5 plus 12.
Yes, that's all right.
5 plus 12.
What my humble submission is, let them deposit the entire amount.
And that no.
They themselves, because I have cross-checked.
I have said that.
They themselves have cross-checked. It's there, Milords, in the
video itself.
I'm sorry. Yes, there. I have cross-checked.
I wouldn't make this submission. I would not resile from the statement I make, my lords. But for this 12, I am asking for life support, my lords, and he is expecting 32.
No. I am not expecting 32. It is something that is under the IBC.
You had said that. That's what he is saying.
My lords,
this court-wide order dated 25/2/2026 had said as an next one. Learned appearing for the petitioner submits that in terms of the said order, the first installment of rupees 5 lakh has already been remitted. 5 crore has already been remitted to the registry of this court, and his client needs a short accommodation extension for making payment of the second installment, 25 at rupees
12 crores.
12 crore. First term. Learned counsel representing the auction buyer also seeks time to have instructions from his client as to what should happen in the matter. If solatium is offered, if reasonable solatium is offered. First up, Mr. Samantre also submits that for the delayed payment in the making, his client would pay some reasonable additional sum as well. First up. This is fair enough. Next one.
The interest, Millets, is 12% as per IBC itself.
That is 12% interest as per the IBC. First up. Next one. In the above circumstances, the application having been favored, petitioner is the extension is granted till 31/3/2026.
Millets, the original order 25th February, say from 25th February till 11th March. The original order gave them, Millets, your lordships, and the subsequent order is
after all he is going to be 5 crore he has already deposited.
With the registry, it's not going to
this version.
It's not going to the liquidation account, Millets, as yet.
It is with the registry of this court.
The remaining amount that they deposit, let it be deposited with the liquidator.
No, have already deposited it in the registry. But you are directed.
Which is the bank?
Till 31st March of 2026.
And it is public money
subject
after
to the condition
Canara
that
Bank
petitioner shall deposit another sum of rupees 50 lakh. Additional sum of rupees 50 lakh. Another 50 lakhs you have to deposit here.
Please, Lord.
Wait. If it is 12%, that will not work out. Let it be 50 lakhs. First comes. Next paragraph. It is made clear that if the benefit of this extension is not availed, petition itself will be dismissed on the next date of hearing. Call this matter on 6/4. 6/4. Okay.
Well, can it be a Tuesday? 7th, because 6th is
7/4.
Yeah.
Please.
Next.
Item 32, WBC 5791/2026.
Send it to the way.
And I am referring from the
Mantre, in the event of dismissal, this amount deposited here will go to the OL office, not to you. It is further made clear that in that event, the amount deposited shall go to the account of the OL.
Whereas I am in the lordships and whatever lordships.
No, because natural. Otherwise, we will be doing injustice to others.
Definitely.
Okay.
Grateful, Lord.
Item 32.
May I please, my lord?
Yes.
I am appearing for the opposite partner 1 to 4. 1 to 4.
I am appearing from the petitioner. Short adjournment.
You want adjournment? 3 weeks at the request of counsel for the petitioner. Yes.
Interim order to continue.
Interim order to continue till next date of hearing. Yes.
Item 26, WBC 28409/2025.
Of the petitioner bank, I am going for declaration of the Hon'Ble court that I am the first charge holder.
Declaration
that I am the first charge holder of the property.
Who are you?
I am the petitioner bank. I am the opposite party number 2 to 4 mortgage the property.
When the mortgage took place?
My lord, your lordship kindly see page.
My lord, may I please? Same set of facts, same relief has been prayed in securitization appeal number 164 by 20. That is pending before the DR.
My lord, so
Same
far
set of facts.
This,
2 to 4. Who are they?
borrower and mortgage.
Borrower.
Borrower and mortgage.
You want to duplicate the prayer here? You are claiming the same prayer
what
there.
I am praying here for declaration of the first charge holder.
Why we should
That is, that is within the jurisdiction of this honorable court, my lord.
No.
That's not jurisdiction.
We'll tell them. We'll
My
tell
lord,
them.
Your lordship kindly see the SI Act.
Your lordship.
Who are you?
I am
You are the
petitioner bank. The opposite party number 1 is LIC.
I think it's covered by the judgment of apex court, na? Bank will have the priority.
Your lordship.
Priority.
Bank will have the priority. Section itself says that.
Your lordship, I am auction
also there. One government is also there. If in a dispute regarding the financial institution and the bank, then the section 11 Suppression Act is applicable. Arbitration is there.
So far, this case is an instant case is concerned that Nangli right.
No, how you are aggrieved if a priority is given to the bank?
Your lordship.
It will inure to your benefit only. As against other claimants, law is that this is the priority as against whom?
The property which has been mortgaged against LIC. How she
against LIC.
Mine.
The
opposite party number 1 has given mortgage for same property.
When loan was given by you, which date?
Mine. Lordship kindly turn to.
We will not turn any page. Tell the date. We are not here to turn the pages. It's your job.
There are many disputed facts stated in the
What is disputed? I'll record. Yes.
Well, he has approached.
What approach? When did you sanction the loan? When the mortgage is created?
Page 6, I have mentioned. Sanction letter dated 16/5/2017.
When the mortgage took place. Mortgage is the point. That's what the apex 2017.
Mortgage that has been registered in Sersai, your lordship turn to page 30.
I will not turn any page. You have to tell the date. When the mortgage is
13/12/2017.
13/12/2017. You don't have your. They are telling it. Pages here. Okay.
Page 33. That is registered on 13/12/2017.
When did you LIC lend the money?
Well, because that I have to take instruction from them because I have not filed counter in this case.
What
because
that is the only date.
The same set of facts.
All right, but you have said that, na? Now you have said.
There are some disputed questions of fact, date of mortgage, date of sanction. There
What
is
is
some
the registered mortgage deed? What is the disputed fact? Registered mortgage deed.
It's,
No, this is equitable mortgage registered with the central government.
Yeah, registered with that's what?
deposit of title deed because here we are accepting deposit of title deed. We are giving loan
by
deposit of title deed.
Mortgage.
Your Lordship, I would like to submit. I am the auction purchaser. The bank has already auctioned the property, and I have already purchased the property.
The money.
Yes, I have already deposited the money, and the land is already registered on my name. Then after that, we came to know that
we are not unable to deliver the possession.
Yes, I have not got the position. LIS took the position.
See, he is a brother. He is the auction buyer of the property. He will take the property. And that will be subject to your mortgage. Whatever arrangement you have, that it will be subject to that. What you are a buyer, borrower, you are a borrower. What does that mean? You have nothing to do with the borrower. You have said it 10 times now, everybody. You want to defraud them or what? Sit down, don't speak unnecessary. What is your grievance? You cannot have any grievance at all. You are a borrower. Question is, as between two lenders, question is there now. Not you.
We have also mortgage were registered in 2019.
2019. Obviously, you are subsequent mortgage. So naturally, they will have priority even under law of mortgages. When a property is mortgaged, see, sale exchange, gift. These are three transfers where entire ownership is changed. Lease and mortgage are two more modes where limited ownership is transferred, limited interest is transferred. Is it not? In case of a mortgage, there is creation of interest in the property for securing the repayment of the debt. Another point. After the mortgage is made, the owner's interest, mortgager's interest in the property is called equity of redemption. That equity is also a property. You are holding that property. Because first mortgage is dated 13/12/2017. Your mortgage is, you are a puny mortgagee. What's the point? Therefore, we need not travel to this section at all. Even under the law of mortgages, the successive mortgages are subject to earlier mortgages. That is the only issue. We are making that observation.
Your Lordship, I would like to submit one thing. In CRSI, that report, the plot number is 94/5121. In another CSI report, in which according to which LIC Finance has taken the position that plot number is 84/5121. So there is, the property is showing same, but the number is different.
Plot number different.
Anyway, number is
Second aspect is
property
that
same is admitted.
the LIC has played fraud while taking mortgage of that same property.
How can we say that?
They are entitled to take another mortgage, na? Subsequent mortgage is not prohibited in law. A property can be mortgaged to any number of people. But each subsequent mortgage is subject to the earlier one. Yes. That's all. I can mortgage my property. Suppose if a Maharaja mortgages his palace to 12 people, can you say that he cannot do? He can always. Now, even going by, even going by the mortgage dates, yours is a subsequent mortgage. That's all. The yours is dated what?
No, my lord. Your Lordship, kindly see page 32.
My mortgage registered on 2/1/2019. 2/1/2019. Page 17 of the brief may kindly see.
66. That has been
Para 5.1.
66.
That property is not at all mortgaged.
No, my lord. Another aspect is that one thing is that second mortgage, second charge holder, that's one aspect. Another thing, while registering the property, they have registered in the wrong, another plot number. While they are attaching the property, they are attaching the property which is mortgaged with petitioner bank. This is very peculiar thing.
So it may not be the same property which has been mortgaged.
Exactly.
So both are different.
Yes.
Property attached. Property attached is not the mortgaged property.
So the property which has been mortgaged with you is not the one is attached.
That is attached, but the same property is not registered with them.
So it is a different property.
Then why they will attach my property?
That is one question.
Your Lordship, I am not able to get that property.
Separate property.
You are not the petitioner. You are only opponent. You can resist the petitions, or you can say allow the petitions.
He is the auction purchaser.
I am the auction.
Correct, but you should have done. You cannot do because
I am unable to deliver the proper possession only because before my taking physical possession, LIC has taken the physical possession.
You have taken physical possession of the property.
Unable to take the. They have taken.
We will do one thing. We will direct the ERT to decide this aspect also.
Exactly. That is why I'm
prescribe the time limit. Doing.
That is why I suggested in the initial.
Till then, status quo so far property is concerned.
Right. Correct. Well, who are you? You are only borrower. It is between lenders they are fighting.
In that essay, they are also party.
Find the counter, you must find an essay before the DRT. That is also pending. That's why my senior.
Therefore, let DRT decide.
Yes.
Let DRT also should not decide the matter. We also should not decide.
So what is your SA number?
No, brother, no.
What is your SA number?
There is a bank SA is 664/25.
There are three SIs are pending. You will kindly see there are three SIs.
Yes. Yours is?
One is SA 97 of 2021.
Your petitioner's essay is what?
My
164/25
of 2025.
Borrower's
Borrower is SA 97 of 2021. The borrower also filed another essay challenging the action of the LIC Housing Finance. That is SA 138 of 2024.
This 97 of 21 is against you.
My lord. My possession notice is under challenge.
1 second. And
Against LIC is?
Against LIC is essay number?
138 of 2024. That is borrower and mortgagor, they have filed. And so far petitioner bank is concerned, SA 164 of 2020.
Yes. Petition prayer reads as under. First, OP number OP number 1 happens to be LIC Housing Finance Limited, which claims to hold mortgage of the said property, while mortgage deed dated 2/1/2019, that is 19, petitioner's mortgage deed being 13/12 being of 13/12/2017. First, the dispute essentially relates to priority of claims of competing mortgages. First, the issue is made a bit complex because the OP number 1 LIC Housing Limited, Housing Finance Limited is said to have taken physical possession of the security property on section 14 order.
Taken possession at the just time. On 18/7/2025.
18/7/2025.
In bank miscase number 16/24. 16/7/2025. In bank miscase number 16 of 24.
He does not come from Oxford. He's a product of Cuttack. Thank you. Yeah. Wide order dated taken on
16/7/2025. In bank number 16 of 24.
In
bank miscase number 16 of 24.
Number 16 of 24.
16 of 2024. Filed under section 14 it is.
After obtaining the order, they have.
It is under
possession notice. Under section 13 of Securitization Act.
How it travels?
Then why miscase?
Case.
My lord?
How miscase is there then? Bank miscase is before whom? If it is not before
that is
for the
amendment. Therefore 14. Filed under section 14 of the Surface Act 2002. First. Next. Learned counsel for the petitioner bank submits that even going by the dates of mortgages, that is 13/12/2017 of petitioner's mortgage and 2/1/2019 of first OP's mortgage, the priority of claim would tilt in favor of the bank itself. First, learned panel counsel appearing for the OP1 per contra submits, this issue need not be examined by the writ court, in as much as the very same issue can be raised in the pending essay number 164 by 2025, petitioners essay number 164 bar 2025, comma, coupled with the loanees essay numbers 97 bar 2021 against the petitioner bank and essay number 138 of 2024 against OP1. First up, whether all they are clubbed together.
Your Lordship.
We are told that all these
not yet tagged. Not yet tagged.
Okay. But first up, learned counsel appearing for the auction buyer ventilates his grievance that despite the payment of the auction money, he is not able to get the property to his hands. First up, learned counsel appearing for the OP loanee seeks time, which we do not agree to give, since he is not the stakeholder in this case. First up, next paragraph. The actual stakeholders in the petition, namely the petitioner on the one side and OP number 1 LIC Housing Finance Limited on the other, very fairly submit. We'll say you agree to our suggestion instead of you submitting.
Yes.
Very fairly agree with our suggestion that the issue ventilated before this court in the present petition can be examined by the DRT Cadre, which before whom the aforesaid 3 essays are pending consideration between the parties. First time. They're right also in telling that all these essays should be directed to be clubbed so that there would be no scope for conflicting orders. Orders. The one Supreme Court said there are several essays between the next paragraph. In the above circumstances, this petition is disposed of, permitting the petitioner to press into service all contentions and prayers made in the petition before the DRT in its essay number 164 bar 2025. First up, the DRT shall club all the 3 essays, namely essay number 164 bar 25, essay number 97 bar 2021, and essay number 138 of 2024. And hear them. First up, it is open to DRT to pass separate orders in one single judgment. First up, all contentions of the parties are kept open. First up, call on the essays, all the essays should be heard and disposed of within an outer limit of 3 months.
Actually, since 2 years we are waiting.
Therefore, 3 months we have made it. 3 months, within an outer limit of 3 months. Because so many other matters are there. Okay.
Only.
That's all.
Well, so far, interim order is constitutional, that was that proper.
the OP number 1 shall not alienate or encumber the subject property till essays are disposed of. Okay.
Item 29, WBC 603 of 2026.
May I please? In this case, I am for the petitioner. He has taken a passover on behalf of the Cadre. I have given the copy since long.
Because
Highly obliged. Because I have challenged the CAD and pray for a stay order. Obliged, highly obliged.
You just sought for a stay order.
Stay order. That is because of this is a sexual harassment by the senior teacher.
But the counsel is on his feet.
He is on his legs. His junior has to present because your lordship director twice he has given her. Your lordship's memory twice he has taken a time. First he has taken the Hon'Ble's, then counterfile. No, but obliged, highly obliged. In the supplemental.
Next.
This is over.
This is over now. Yeah, so we take the brother was to 345. Yes, they take other matters.
Fulfill list item 19.
19.
Yeah.
The limitations of the first is 42 days limitation. 5 days delay.
19 is by whom?
I am the.
You are for the
appellant.
Notice is already.
All have appeared.
Who appears for the OP?
Learned senior counsel, Mr. Manoj Mishra was appearing in some cases. Senior counsel, Mr. P.K. Rath is appearing. You are present some of today. Let's may fix it to next week so that it can.
Call this man on 6-4. Call this man on 6-4 to enable advocates to come and document. Yes.
They are absent. So they are.
The last sentence may not call on 6 at the request of the one.
Senior has come.
Okay. Let him start. You have come running now. Yes, anyway, we are having tomorrow.
Tomorrow or next week?
Next week.
I have got some. Just a minute.
Always you are mentioned.
Why so much? You should resist temptation. That is. On 70, how many matters are posted?
70.
18 matters. 16. 15 matters. You put it that itself. Let us see. On Monday.
Obliged. 16.
You should not trouble senior. They have to come all the way running like that. You should not do that way.
He is more interested. But all right, I've not killed it.
I have accommodated thrice to my senior. Always I am accommodated. Yes.
It was accommodated.
No, I have always accommodated. Also. And
yes.
Fulfill list item 31. WA 3206 of 2024.
Yes.
It is a case of some area salary and gratuity.
Yes.
Consequent upon
who is your opponent?
My lord, the tribe, large state also, but the exact mine DTO, drawing dispersing officer, for whom I was serving, and if entitlement is decided, I will get it. Large site, managing director, large site, multipurpose cooperative society, OP number 6.
Who is the answering OP?
My lord, Lam, managing director Lam.
He is not here.
So, notice issued thrice, my lord. For this single charge also, special messenger, registered post, speed post.
Will issue police notice to them.
Yes.
Issue police notice to.
OP number.
OP number? OP number?
Yes, my lord. OP number. OP number 6, my lord.
OP number 6.
Or lamps.
Lamp.
Large area, multi-purpose.
Large site.
The government, what?
Working under the registered cooperative society.
Register of cooperative society. But why?
So register maybe.
Pin number 2 is the registered cooperative society.
Register.
But
But answering OP is 6.
6.
He is not coming before the court. Should he not send a letter to some lawyer or one letter saying that we are not interested in fighting this case, whatever you want to do, do.
Possibly notice.
Yes, authority.
It's not a private party. It's a Article 12 entity. Within 2 weeks.
Before the registrar, when the one of the case was
answer. Notice back from.
Therefore, we'll send the police notice to.
Well, they were coming before the registrar when the personal hearing was.
Post immediately after service. The police is warned to serve the notice immediately and send report to the registry. Yes. Date cannot be because service has to happen. Yes. Immediately after service, we are posting.
Yes, sir.
Yes. Post this matter immediately after service. So even for condoning delay, we have to do that. Yes.
Okay, list item 38, WA 3363 of 2024.
It was urgent in the first. Kali last hour mention.
Which one, sir? Your matter.
Yes, my lord. My delay is 175 days.
No, somebody took time, na?
Correct. Yesterday has made a mention.
Yesterday has mentioned. We'll have it next week. Next week. Yes.
Item 39, WA 29525.
My lord, I may be extremely sorry, my lord. I was just running to this, your lordship's court.
9.
But item 19. Mr.
Just 5 minutes.
No, my lord, it has been adjourned, my lord. I was just running to your lordship's court. Shortly,
we have adjourned it to which day?
No, your lordship.
6th of April.
6th of April.
6th of April.
6th of April. Because nobody was there.
No, actually, I was running to the lordship. The other assistants also.
It's all right for you.
My lord, I waited a little bit early, but your lordship.
No, whichever date you want.
My lord.
Choose which date you want.
My lord, 31st.
All right, 31st.
Most obliged.
March.
Yes, next. But inform your friend also.
Yes, my lord. Just
Item 39. Item 39.
None appears for the petitioner or appellant? Petitioner.
Appellant. This is the appellant. This is Staff Selection Commission is the respondent. But in
which the commission? What is this matter? Anything can be done in his absence.
2 million of page 37. The similar matters was disposed of on 14.1 and thereafter million under annexer 3 at page 45. Same has been decided by this Hon'Ble Court in coordinate bench. It is 13/7/10/2022.
Dismissed.
Yes.
Covered by judgment.
Covered by judgment. That is annexer 2 and 3. I have given.
Just 2 and 3. What are the first two? Just listen. Your matter. Yes.
I'm sorry, my lord.
No, take rest. 5 minutes. You should take another matter. But anyway, he is saying it is covered by the judgment.
Annexer 2 and 3.
Covered by the judgment in your favor.
It's a delay was on 31 days. My learned senior friend has entered appearance.
Yes.
Writ appeal.
Will condone delay.
131 days.
This appeal, intercourt appeal, seeks to lay a challenge to a learned single judge's order dated 9/8/2024, entered in 24, whereby respondent employees WPC number 21977 of 2014 having been favored, the following have been accorded to him or her.
To her.
To her. To her.
I think it's
Level.
the people fit.
Para level. Okay. Next paragraph. Learn it. Then
It needs, Your Lordship may hear this man. This, if Your Lordship, if I take a minute from Your Lordship's board.
Yeah.
Here, my lords, this writ appeal was just a disposal of another writ petition. No issues were dwelt in this writ appeal and it has not been decided on merit. Be that as it may, even if the petitioner in that writ petition vis-à-vis the writ appeal, the stand and the status of that petitioner is totally different from that of the petitioner who is before Your Lordship now, as a respondent. The writ appeal which the United States Council suggests here is relating to posts which were not created, rather were temporarily posts were created, filled up temporarily. In this writ petition, which the Honorable Single Judge has passed an order.
Regular post.
Yes, they were created. And prior to me, the persons who were manning that post were regularly appointed. And I was only given an appointment on a contractual basis. And after me, such posts are also treated to be regular. So I am claiming regularization vis-a-vis protection of the salary. They paid me only 9,000 per month, whereas similarly situated persons performing identical nature of work, they were getting more salary in a scale of pay.
Is it a pay scale? 9,300 to 34,800.
Yes.
With great pay of 4,200.
My lords. But they were paying me in a consolidated amount.
That they could not have given.
Yes.
Your appointment is against regular vacancy.
Yes.
You were appointed on which date?
I was appointed as an Angan. First, my lords, if I take Your Lordship a minute, I was appointed as an Anganbadi worker. Now the scheme comes in my favor, in favor of such Anganbadi workers who would be either rendering 5 years of continuous service or secure a graduation. Then they will be treated to be Anganbadi supervisors with a schematic formation of their nature of appointment as well as the conduct of selection.
You fit into first category.
Yes, I was number 1 in the gradation list of being appointed as an Anganbadi supervisor, my lord.
Oh, you are in second category or first category?
Supervisor means second category.
Second category.
Supervisor, second category. Now my gradation list was, in the gradation list, my position was number 1. Then, my lords, what happened? In the meantime, the state government introduced a further circular that even matriculate Anganbadi workers who had conducted or served more than 5 years, they can also be considered for Anganbadi supervisor posts as per the Rule 8 of the scheme. Now, when I was under duress, my selection, I was within 20 to 25 persons were selected to be appointed during my time. 18 persons were appointed. Some persons could not be appointed due to paucity of vacancies. Now, when these vacancies came up, the government suggested us, you have to be there if you take an undertaking that you would not claim any regular scale of pay, and we were only appointed as Anganwadi supervisors, performing the same nature of duties as of regular hands, but we were granted only 9,000 consolidated salary. Now, after me, that particular phase, when was over, then further vacancies were there. Now, for such vacancies, the state government fulfilled the posts out of the select list where I was there, and
from the same list.
My lords.
From the same select list.
Same select list, and further selectees of matriculation Anganwadi workers.
They are given regular pay.
Yes, they were paid regular scale.
You are not given.
No.
You are given consolidated pay.
Consolidated 9 months. Then I came up before this Honorable Court. Thereafter, Your Lordship directed the collector to take a decision on my grievance. Now the collector, being my appointing authority, suggests and finds out in his own order that yes, there has been a irregularity which which needed to be taken care of by the government, and recommended my case to the government for a clarification. The clarification didn't come. Then I came before Your Lordships again. Your Lordships decided that since I have been working in a post of Anganwadi supervisor created by the state government, and I am performing the same nature of duties as that of other set of Anganwadi supervisors earning a higher scale of pay, I should be protected by Your Lordships. That is the order now they are challenging. They are taking the leaf out of a writ appeal which has been passed by this Honorable Court on the ground that that is related to 2 posts which were created and filled up temporarily.
Whereas yours is a permanent post.
Yes.
Regular post.
Yes, ma'am. These are the issues. Now, if I seek Your Lordship's permission, I have made 2 sets of documents. One document I have placed before Your Lordship that would suffice, that the state government, in its own wisdom, in the meantime, have issued a circular regularizing all these Anganwadi workers, which my learned friend suggested cannot be, with effect from 2024, just after my retirement. Now, these Anganwadi supervisors, I am giving 2 sets of these documents for Your Lordship's perusal only. These are 3 judgments and 1 copy of the notification, gazette notification of the state government.
Which judgment supports your case?
My lords, that is of Dharampal Singh. One is Dharampal and another one is State of Punjab and others versus the senior vocational staffs, Master Association and others. There, their lordships.
Any of our judgments treat this?
These are of Supreme Court's, my lords. Supreme Court.
Our judgments are there.
I'm sorry, my lords, I haven't got one. If I beg Your Lordships to kindly see the first notification of the first page, that is though marked as serial number 4, but it is at the first page of Your Lordship's compilation that I've given. It is a resolution, Government of Orissa.
Mr. Mohanty, if you have done from choosing from the same select list.
I'm coming. The Anganwadi worker, those who have been appointed me, the present petitioner is at 1983.
Correct.
Normally, in normal course, they will be promoted to the post of supervisor after lapse of 10 years. In between, government has made a circular. The person from among the
Anganwadi workers,
those who have completed graduation, they will be relaxed at the age of 5 years, in place of 10 years, and they will give an option if at all they want to be promoted to the post of supervisor and contractual, they can avail that opportunity, keeping in view their option exercise. If at all they don't exercise that, absolutely fine. Then after 10 years, they will be promoted to the post.
This will give a concession of 5 years.
Exactly, keeping in view their
qualification and graduation.
Accordingly, this present opposite party and the petitioner in the writ application has exercised that option, because 5 years before he can get the benefit, even though it is contractual.
So he became supervisor.
Exactly.
Yes.
That
he became supervisor.
Supervisor. That has been exercised by the.
Correct. Once she becomes the supervisor, and the remuneration which you will pay
on contractual matter, that is the condition.
That was contractual.
That is the condition.
But what you have done to other people?
Other people after 10 years who will get that is a regular miller?
Oh, no. Then what is fun in having 5 years?
Because of keeping in view their qualification, being a graduate.
No, that
and
will
continue to be in consolidated, 9,000. That is the point.
Before 5 years. That has not been challenged.
No, we don't agree. They are not
on that point, kind of a glance to page 25%.
No, we are by your
judgment is at answer to page 37.
7.
Yes.
See, brother Mohanty, if your objective to cut short that period of 10 years to 5, whatever benefit they would get after 10 years should be granted after the 5 years. Otherwise, that is the policy.
That policy is
Otherwise,
they may not go for option. If I will opt for the same, before 5 years, they have the option to be promoted to the post of supervisor.
Correct. So he came
with a consolidation.
He came to be he was placed in the post of supervisor only.
Supervisor.
Because he acquired graduation.
Graduation.
Is it not?
That is
and
option.
coupled with his option.
It is optional.
Optional. Yes. So whatever he would have got had he been there for 10 years without graduation.
So normal way he will be promoted as a regular
base.
Super.
Then how can you deny that skill?
That has not been challenged, Mel.
No.
Well, can have a glance to the judgment.
Yes.
That is important. Page 37.
Now, learned single judge has said that.
Yes, ma'am.
You pay you have to make the payment
but
in the
on
pay
that
slip.
score, my lord, this honorable court has been pleased to pass an order
saying
on exactly on that point, which has been decided in the writ appeal by this honorable court.
You know, those were the cases which your friend was saying. He's our friend also, is another thing. He was saying that those were the cases wherein appointment was made on temporary basis and against non-sanctioned posts. Here is a case where the appointment is made against the existing vacancy, against sanctioned.
In all the Anganwadi workers, they are against the existing.
No, but they were temporary posts. That's what.
Temporary adjustment in the post of supervisor by exercising their option. The very initial appointment was not there.
But you are correct. Even his initial appointment is not a supervisor. His initial appointment is Anganwadi worker only.
Anganwadi worker.
He became supervisor because of his acquiring graduation coupled with exercising. Done. If that is so, how can you...
Similar and identical cases, identical cases under Annex 2 and 3.
Let us go to Annex 2.
2 for a moment, 37. The second paragraph. The impact of the case of the petitioner is that the Women and Child Development Department has floated a scheme popularly known as Anganwadi worker under this.
No, this is learned single judge's order.
Yes. Subsequently, we at Annex 3, page 45.
Affirmed by the division bench.
Yes, ma'am. By this and all.
Let us see what are the fact metrics of promotion regular basis having been appointed to contract to. Let me be unable to point out what the checking is being made. Where is the reasoning of this kind of order? Where is the reasoning of the judgment? This is only one line edict, not a judgment. Where is the reasoning? In that was a case where, see, he is not in a position to show. Even before this, the appellant is unable to point out on what basis such a claim is being made. He is saying, I am making the claim because under the policy of the state, after 5 years, I become supervisor because of my value addition.
Exactly.
Coupled with my
option exercise. Para 2 of the writ appeal. The learned single judge has rightly noted the distinction between contractual appointment and a regular appointment. The appellant was unable to demonstrate, even before the learned single judge, that she had any accrued right of promotion on a regular basis, having been appointed on contractual basis by exercising that option.
And then suppose if they are promoted, you mean to say this promotion is on contract basis?
Before 5 years?
No, after 5 years.
After 5 years, 10 years, usual.
10 years, usual.
10 years is
regular. Then again,
that is the finding.
We have understood. What we do not agree with that is, it is not loaded with the reasoning at all. Where is the jurisprudential reasoning in the judgment of the coordinate bench?
Let my learned senior friend respond to it. I'll find the details and hearing of this matter.
I have already enclosed this Honorable Single Judge's order in my writ application. There I have stated therein that the decision as has been rendered by this Honorable Court, by the Honorable Single Judge, is not applicable to my case, because for my case, I had given a notification of the government by virtue of which government had pleased to open 409 such posts where I was in my center.
On regular basis?
Yes.
Where is that notification?
That notification, my lords, I had that the learned single judge has taken note of. That is at Annexure 12, page 8, running page 108 of the writ application for your lordship. If the writ petition bearing number 21977 of 2014, if it is before your lordship, then I would beg your lordships to kindly peruse page 108, Annexure 12.
Supervisor, 486 posts.
Yes, my lords. Then I take your lordships to page 110. I take your lordships to page 110 and I beg your lordships to kindly see serial number 48. That is the name of my ICDS, Bodchona, where 4 Anganwadi supervisor posts are created. Could your lordship get it? Out of these 4, I have been appointed against one of such posts.
As a regular appointment only?
Yes, my lords. And the scheme itself says...
Where is the treatment of this contention with the learned single judge?
Your lordship sees the order which has been challenged before this honorable court is...
Which paragraph learned single judge has stated?
Page 33 of the writ appeal.
31.
25 is the impugned judgment. The state government challenges before this honorable court, my lords.
It starts from page 25.
It starts from page 25. I beg your lordships to go to page 33. Mid of the paragraph. Here was page 33. If I read with your lordship subject to permission.
Paragraph?
It's a continuing paragraph, my lords. Page 33, that the petitioner ought to have been promoted as ICTS supervisor on regular basis. There is no plausible explanation forthcoming from the side of the state for engaging the petitioner on contractual basis and thereby paying her less salary than what it would have been entitled.
Mr. Mohanty, there is nothing. There is a finding coupled with the...
And thereafter, my lord, further, this court also finds that the post of supervisor was created by the government on regular basis as per order dated 11/2/1997. That is what Annexure
8.
Yes, my lords.
Nothing. Merely because you have taken his consent, he cannot result from that undertaking. That by the learned single judge pursuant to inland water.
But inland water.
Inland water as well as Dharampalma.
But this judgment and the writ appeal, thus had not been placed.
No, may not be necessary. It may not be necessary. There they were not, see, it was such a frugal order with due respect to the bench. With the due respect. It is bereft of reasoning. It is bereft of reasoning, to say the least. We cannot say more because it's a coordinate bench. Only this much we will say. It is bereft of reasoning. It is bereft of justice. Where is the justice element in that judgment?
May I say me?
No, nothing like that.
Can I take one day
nothing.
to visualize that status and the present petitioner status?
Call this matter.
Monday, Milo. Monday.
Thank you,
If it is distinguished, then I will not stand on the open.
Very good mind. No, you have made your effort. We appreciate that. You have made your effort.
On Monday.
But for my satisfaction, one line submission to your lordships, subject to your lordships approval,
in the Dharampal Singh's case, Honorable Supreme Court has categorically held such a condition was incorporated in an undertaking taken from the employee, which was held by this court to be contrary to the public policy.
Correct, because
That is also in
the
Volana.
persons who want job,
Yes.
they will do anything to which you say. This is a country where poverty, especially in this state. What is that? Angarwadi supervisor, not deputy commissioner's post.
No, because of that option and that I will distinguish. If at all it is not coming within that purview, then
Sir,
definitely.
Monday we will have.
As your option.
Pardon me, Lord, item 39, I was absent. We held up in some other court. I have taken up tomorrow, my Lord.
No, you passes the order.
I held up in some other court, my Lord.
Item number 48, revenue election. A copy may be served so that I can file objection to the limitation. There is 311 days delay, Your Lordship.
Who has to give copy?
State.
State has. Mr. Bant, you give copy.
Item 41, next item.
41, which year?
41 of
25.
25. We will accommodate.